Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict's live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican police service lieutenant.
Literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for crumb's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Hope you're doing just fine this morning. Music's just a little bit loud. Here we are. Good morning. Points are pointless. Thank you very much, Red Pen, for that. First thing off the top, Regina Adams. Regina, you're first in line, first in chat, first to break the stillness, the silence of the morning. And for that, we're going to punish you. Everything I-related worldwide is your responsibility. That's it. We're sentencing you to internet ownership. That'll teach you. Regina, thank you very much for being first. Somebody had to do it. Today it was you. Fran says, I thought we wouldn't see you till this afternoon. This afternoon is when the Charlie Kirk accused killer Tyler Robinson pre-trial hearing happens. Wow, I said that all backwards. That starts at 3 o'clock Eastern. It's only a half day, and we're halfway done with that pre-trial hearing, believe it or not. On the calendar, we're halfway done. I'm not sure if we're actually halfway done or not. But anyway, we've got that has started at 3 o'clock, so we're going to do a little bit of court hopping and some catch-up with some of our favorite courts around the country this morning. And if there are any documents out there you guys saw dropped recently that you need me to read, send them to me for my consideration. Most of them I won't read, though. I got a lot of documents sent to me, a ton, like more than most courts. I got a lot of documents sent to me. We'll try to see if we can find some that are relevant. If you guys need to have me read something to you and try to explain it. But we are here. Good morning. There's one thing we have to get out of the way first before we go. Don't say I didn't warn you. Don't say I didn't warn you.
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. Can you bring me some water, bud? I knew that would get you in. Thanks. Thank you for the thumbs up. Yeah, I need water now. Just a mild one, just a short little hump day yell. We are halfway through the work week. For those of you who aren't counting or who should be counting and forgot where we were, we are on Wednesday. It's also garbage day for me, so this is how I remember the hump day yell. If I yell hump day and I haven't taken the garbage out, that means that I've missed it. There needs to be an earlier reminder. Blowing my ears out while I'm at the office is a great way for me to unsubscribe. Yes, that's a risk we take every Wednesday. That's why it comes with the warning. Let's see. You were warned, right? The warning goes out. All right. Well, I was late. Came into that. Good morning. Yes. Thank you, bud. Appreciate it. Ooh, 5. Delicious Deer Park water. Not a sponsor. Still, Deer Park's like, why would we sponsor him? He's our best customer. I have to stage them. All right. Let's see. Hump day is garbage day. That tracks. Yes. It's par for the course is what we like to say. We do have a birthday. That's awesome. We'll celebrate a birthday, and then we'll start jumping around to courts and possibly talk about Tyler Robinson a little bit this morning as far as the trial, what we learned yesterday between all the objections. And I have Alexa remind me to take the garbage out and to take my medicine. Rebecca, hey, bite me. There's a billboard in my town that says, bite me on it. I need to take a picture of it. It's a mosquito company or something, which I think is okay, but it says, bite me in big letters. I've got to take a picture of it for you. because you're famous now. You're famous. Let's see. Happy birthday to Baby P. Is this Josh's? Is this Josh's nephew? Just trying to see. We're going to sing to Baby P here in just a minute. No other birthdays to sing to? Make yourself known or forever hold your peace. Baby P is Josh's nephew. Okay, all right. We're gonna sing to Baby P, who was born yesterday, and then we're gonna begin the court watch. So everyone, wherever you are, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. That'll do. Happy birthday to you. Happy birthday to you. Happy birthday, dear Baby P. Josh is a great uncle. Happy birthday to you. I'm not saying he's a great uncle, like great uncle. He's just a great uncle. That's what he is. Congratulations, Baby P. Welcome to the world. I'm sorry. We're trying to fix it. That's all. We apologize for what you have. We're doing our best to fix the part that we did. So happy birthday. I realize there are, probably only one other place you could have been, honestly. And you chose to be here with us. The privilege, the pleasure, the honor, the joy, that's ours. Hopefully we can turn that joy back to you, make your day a little more special. And begin by helping yourself to baby food pancakes. Available at none of the following establishments: Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlop's House, Sandy's Grill, Bob Evans, and Cracker Barrel. Yeah, you have to sort of make your own baby food pancakes, which I don't think you can even get syrup. I'm sorry, you're just too young. You're too young. It needs to be pureed in the Ninja. Happy birthday, Baby P. That's awesome. Welcome. Josh is a very good uncle. He's super excited. Tammy's like, wait, I can do it. Baby food pancakes. Yeah, if you want them, Tammy, are you in Germany right now, or are you back in the States? I have to say, we had German pancakes for breakfast. My wife made. Have you ever seen German pancakes? I'm not sure what's in them. More egg than your traditional pancake, I know that. But they grow like out of the pan. They just like explode in size. It's the craziest thing. And then they shrink back down. That's why I'm the Oma. I can do baby pancakes. Wonderful. Drum solo. You can slow that down 120 times, whatever, to a quarter speed, and you will see I nailed every single one of those beats. I'm basically a professional air drummer at this point. Anyway, happy birthday to those who are celebrating Baby P. It's just you today, but we love it. We love it. Bada bing, bada boom. And now, a couple things to talk about. I sort of glanced over this a little bit. Yesterday. We heard some pretty interesting testimony about DNA between a lot of very uninteresting testimony about DNA. And it took a great deal of time, thanks to the defense, who probably went deeper into the DNA dive than most trials ever have, which was also par for the course. And the interesting part is whose DNA showed up in these locations: the towel, the screwdriver, and I think possibly on the firearm, which was wrapped in the towel, so it could be transferred DNA there. Lance Twiggs. Lance's DNA showed up. They did live together, but from an investigative standpoint, I wonder how much at this point the investigators wondered if they had someone who was helping, at least at some level, not necessarily two gunmen. I'm not trying to push that narrative at all, but I'm wondering if they, how far they dug into the idea that there was a possibility that that he might have had support in some, even very limited, just giving him something or getting something for him and making sure he received it. Interesting. We'll see. And it also could be just what you mean. You just happen to have items that were brought from a home where two people reside. And it is expected that household items from a house where two people reside have two people's DNA on them. And that could be it. But this likely contributed to the use immunity. Got a special deal. Let's see. Lance now lives in Texas. He did move. Tahini Taylor, love it here. Hi from Wales. From Wales. Wow. The only thing I know about Wales is I've got a friend that was from Swansea. And he's saying the I Would Walk 500 Miles song like a billion times, because I guess that's also from Wales. Anyway, that's awesome. All right, have you seen the New Mexico versus Isaac trial starting today? No, we're following this one. I've seen there are a lot of trials starting this week, a ton. So we might be going back and doing catch-up on some of those trials as we proceed. After this one's over. Balchley Beach Life Saltaire. That almost got really bad. Beach Life Saltaire. New Color Courthouse OG, 36 months. Congratulations, hit the 3-year mark. That is wonderful. Thank you for that. Also hitting just past the 3-year mark. Tahini Taylor, 37 months. Thank you for your long-term support. 100 Miles is Scottish. Tom Jones is from Wales. I thought it was from Wales. The 500 miles is Wales and 100 miles is Scottish. Is that what you're saying? Anyway, I'm getting my songs mixed up. We are trying to go to court really quickly to see what's happening. Judge Simpson just shut off his live stream. I'm not sure why. I'm not sure what he was doing. It was sort of mid-hearing, and it just boom, gone. Oh, but he's back. He's back. Let's pop over there and see what's up in the great state of Michigan.
It's a PV2. Oh, yes. Oh, so yeah.
Looks like they're just waiting for the judge to show up. And the mics are hot, which is rare. Bailiffs are in the house. Got a yellow sheriff bailiff and a white sheriff bailiff.
Posted. You're talking about the guy that was the other guy. Something.
All right. I live 20 minutes from Swansea.
Oh, yeah.
That song will be in my mind all day. I'm sorry. I didn't sing it, though.
Yeah.
Can you? Okay, let me mute them for just a second while we wait for court to start. We'll keep looking around, see if there's another trial or another court that's actually functioning right now. Update on the YouTube thing. Filed the appeal about the take down the copyright thing on Top Mark Media side, which they granted at 1:21 in the morning. I know this because I was awake when the email came in. 1:21. At 1:28, that same video, the clean feed on Top Mark Media of the Tyler Robinson hearing, got 3 copyright claims, not strikes, 3 copyright claims from a cricket match in India. Because apparently cricket matches in India look a lot like Tyler Robinson preliminary hearings. I kid you not. You can't make this stuff up. What happened is during the lunch break, when the cameraman turned off the camera and the live view bonded cellular encoder defaults to the little live view flopping around on the screen, the little live view brand. Apparently that also happened during the cricket match. And YouTube said, clearly, you're now broadcasting the cricket match because same. Cricket was much more interesting than the Charlie Robinson case, even though no one understands the rules. I think even the players don't. So luckily, because it was less than a 6-hour video, I was able to just say, just trim it out. Just cut out all the parts that they say they own and then put it back up. So they're going to do that, and it will be back up in another hour or so, and it doesn't affect the channel. It's not a problem. It's just a claim they would have gotten ad revenue from it, but they won't now because you can't copyright some other brand name's logo on your screen. I'm sorry. You just can't. And I wish the YouTube algorithm was a little bit better at figuring that out. All right. Let's see. We could go to Judge Phyllis Webster in Kansas. That's a fun one to go visit. Let's check that out.
July 13th, Your Honor.
All right. You are ordered to be back here next Monday, July 13th at 8 a.m.
This looks like traffic court.
Where do you live and work? What town?
I live in Wichita, Kansas, and I'm working at the Cessna Boeing plant.
Well, I question if you're still able, or if you still qualify for court-appointed attorney. You must have. But I wonder if you do now. But for now, I need to get you in front of the court. So July 13th, 8 a.m.
Bowling's a good job. Man, look at that beard.
Mr. Store, any suggestion on whether it be in person or by Zoom?
Your Honor, I think if I get in touch with Mr. Patterson, we can maybe work this out.
Right.
I think Zoom is okay.
All right, I'll let you appear by Zoom. But if you don't appear by Zoom this next hearing, you're going to have all in-person in El Dorado court dates after that. You understand?
Yes, ma'am.
Make it happen.
Question? All right. Now, I will continue the bond you posted. Looks like your most recent one was April 21st to 26th for $2,000, and I will continue that bond. But it's with the added conditions that you contact your attorney today and give him your contact information and follow any instructions he or his staff might give you today. And with the order that you reappear July 13th, 8 a.m. by Zoom.
Okay. Did you refresh me on the attorney's name? Patterson?
Patterson. And then if I said June, I meant July. July 13th at 8 a.m. Darren, D-A-R-R-E-N. Patterson. P-A-T-T-E-R-S-O-N. And I can give you his phone number if you have any way to take it down.
I do, ma'am. Just give me 1 second to find the pen I just had.
Guys, this is your lesson. Let this be a lesson to you. Be ready with pen and paper at all times.
You ready?
I am, ma'am.
It's 316-3
675-3099.
77.
No, 8675309.
Okay, July 13th, 8 a.m.
And that's this upcoming Monday, correct?
Right. This case is 6 years old. We need to get it resolved.
I understand, ma'am. I do apologize. I know it doesn't mean.
And if you can financially hire an attorney, you're sure encouraged to do so. But I'm going to have Mr. Patterson here to try to resolve this case one way or the other.
Save the taxpayers.
All right. Anything further from the state, Mr. Storer?
No, Your Honor. Thank you.
Mr. Machado, anything further?
No, ma'am. I appreciate it.
All right. Well, that's all right. You just be back here, and you may go at this time as you're excused from today's proceedings.
Thank you. Have a nice day.
You're welcome. We'll be just a moment.
Going back to build a couple airplanes now. Judge left us in the dark. I think this is traffic court. Let me check real quick. Is this? Yes, it is. Traffic and reoccurring. Okay. It is a full house.
We'll now take up
Hollywood Squares
Amber
Court.
Murphy On the record in BU 2026 TR 852, State of Kansas versus Amber N. Murphy.
Judge,
appearing for the
your camera's
state.
not on.
Coal store for the state, Your Honor.
And the defendant, Amber Murphy, appears in person pro se. You are Amber Murphy?
Yes, I am.
Very well. Miss Murphy, you're here for first appearance on one charge called operating a motor vehicle without a valid license. This is a B misdemeanor, which means if you were to be convicted, your maximum penalties could be $1,000 fine and 6 months in the county jail. You do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed, or you can waive your right to an attorney and represent yourself. How do you wish to proceed on the issue of an attorney?
I'll waive my right.
You understand that you do have the right to hire, and I can give you time to do that if you wish.
Yes, I understand.
And you understand that if you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed?
Yes, Your Honor.
Knowing this, you wish to waive your right and exercise your right to represent yourself?
Yes.
Is anyone making you give up your right to an attorney?
No, Your Honor.
All right, I will have the record reflect that you are knowingly and voluntarily waiving your right to an attorney.
Terrible idea,
You're
generally.
doing so on the record. How then do you wish to plead to operating a motor vehicle without a valid license? You can plead not guilty, and we can set the matter for trial. You can plead guilty and most likely be found guilty and proceed to sentencing. You can plead no contest, which means you don't admit the charge, but you don't want to deny it and go to trial. Even though you're not admitting it with a no contest plea, you'd still most likely be found guilty and proceed to sentencing today. Another option, depending on what your record is, you could apply for and possibly receive the county attorney's diversion. With diversion, you have to qualify and be approved by the county attorney, and then agree to do certain things like pay fines and costs, a diversion fee, and get your driver's license reinstated. But if you do the things you agree to, they will dismiss the charges and you will not be found guilty and it will not go on your record as a conviction. So do you want to, how do you want to plead, or do you want to apply for diversion?
I would like to apply for diversion, and I already have my driver's license.
All right, in order to give you time to apply for diversion, I must enter a not guilty plea. You can always change that if you need to or want to. And we will set this, when are we setting this for, Jenna?
September 9th at 9 a.m.
September 9th at 10 a.m., did you say?
9 a.m.
9 at 9, all right. You either be diverted or be back here 9 at 9 a.m. Miss Murphy, I'm going to set your bond at 1,000 OR. You won't have to put that money up unless you fail to come to court, but you'll need to go into a breakout room as soon as I release you from my hearing and talk to court security too about the time to do that. If you don't get your picture and prints and set this OR bond, then I'll probably have to issue a warrant for your arrest and make you pay a cash bond. So ask the officer any questions about this process you have. And again, bond is 1,000 OR, and you must reappear 9 at 9 a.m. Now, if you want to look into that diversion, if you're serious, get on the computer as soon as you can to their website. It's BU, it's for Butler County, Kansas, BUCO. Tell me when you're ready.
I'm writing.
Anyone else that might be interested, the website is bucks.gov. And look for the County Attorney's Diversion Program.
In case you want to be diverted today.
Go ahead with your questions.
I understand that I waived everything, I guess, because I was on the understanding my license was not suspended, revoked, or anything like that. My license was just expired. So I already went and obtained my driver's license. So I thought that's all I needed to do.
Well, the question at trial would be, Were you driving on a highway or roadway open to the public in Butler County on April 1st, 2026? And if you were, did you have a valid driver's license at the time? That's the question at trial. Don't answer whether you did or not, but they're looking at the time you were driving. Now, getting your license after the fact definitely has some advantages, such as for the diversion program.
Okay.
But that's also why we have defense attorneys, is because they can help you understand what kind of defense you may or may not have and what you can do with it. So you can represent yourself if you want, or you can hire an attorney, or you can apply for court appointed. But I can't be your attorney and represent you on a defense. You have to hire someone or have one appointed. That's why they're so valuable, is they know the laws, they've studied the laws, they've got degrees in the law, they've got experience generally, and they can help you with any defense you may or may not have. They can tell you if you don't have one.
Okay.
All right. So even though you waived your attorney at this time, you can always get an attorney before you and up until the time you're convicted.
Okay. So
I should say.
September 9th at 9 a.m.
Yes. And
Okay.
if you want to apply for court appointed, contact the clerk of the court. She'll tell you how to get an application in.
Okay.
And now at this time, Mr. Storr, anything further?
Not by the state. Thank you, Judge.
Ms. Murphy, anything further?
No, thank you, Your Honor.
You are welcome. Now look for that invitation on your screen to a breakout room, and you'll be in there with court security too. Jen, if you'd put them together, please.
Okay, thank you.
And Your Honor, I just wanted to put a little bug in your ear. We have a few attorneys on the docket today.
I was noticing that. Let's see. I don't see entries of appearance. Well, I'll do for Jesse Jones Gutierrez. So let's take up.
Your Honor, I'm also here for Jose Del Rio, Your Honor.
Yes, we'll take yours up next. Thank you.
Thank you, Your Honor.
You're welcome. All right, we are on the record in BU 2026 TR 994, State of Kansas versus Ruslan R. Makhmudov. Please announce appearances.
Oh, good morning.
Mr. Storr, are you here on that case?
I apologize, Judge. I spaced out. What was the name?
Rockland.
Makhmudov.
That's a good soundbite.
M-A-H-K.
I apologize,
Found
Judge.
it. All right, I'm here. Cole Storr for the state.
Present for the defendant, and the defendant's also present, Your Honor.
All right, so this is defendant's first appearance. Am I pronouncing your name right, sir? Is it Makhmudov?
Makhmudov. Yes, you did correctly.
Makhmudov.
Okay. Sir, you are here for one count of operating a motor vehicle in violation of your permit, that you are overweight on a commercial vehicle. This is an unclassified misdemeanor. Ms. Gutierrez, how does your client wish to plead or proceed?
Your Honor, I had reached out to the state. We had a valid permit. I provided that to Mr. Storr just a few minutes ago. I had previously contacted Mr. Regier. He hadn't responded to me, so I was hoping the state would dismiss
Mr. Regier dropped the ball.
I don't know if you want to put us in a breakout room to discuss, but that's kind of how we wish to proceed. I know there's some outstanding discovery, so if we're not able to reach an agreement today, I would ask for a continuance.
Well, as I interpret that violation alleged, it's not that he didn't have a permit, but that he was over the weight permitted for. Is that what you're accusing him of, Mr. Storr?
That's my understanding, Judge.
I don't think that's clear from the citation.
You're right. It's not clear because then when I look at the citation itself, permits for oversized or overweight vehicles, fees, 8-1911. It could be they're saying he didn't have the right permit. Here, let me look at the court comments. Stopped with an over-wide load due to the construction zone's width restrictions. The officer stopped him to check his permit. The oversized permit showed that he should have taken US 54 to US 56, also known as 156. then taken US 160 to I-70 by Ellis County. The driver was way off route. I revoked the oversized permit and issued him a citation for violating the permit. So that is what Officer Phillips, or Trooper Phillips, whichever the case may be. Yes, Trooper Phillips wrote it on the court comments at the bottom of his ticket. So that does kind of help clarify that they're saying he violated his ticket.
So it sounds like he got a permit for a wide load and then just followed Siri instead of
he can't
the
do
route he was
diversion
approved on.
because of the CDL. I assume that's a CDL, and they won't. That is commercial vehicle.
Well, I haven't received that portion of the ticket you just read. I haven't received the axon footage, so I was hoping I could work something out with Mr. Storr, but if not, I would ask for a continuance so we can get that additional discovery.
Okay, Mr. Storr, do you feel competent discussing this, or does Mr. Regier need to work with counsel on it?
Judge, I think Mr. Regier should work with her.
You're hosed.
Although I'm happy to, but I don't know if I know enough about this right now to make any decisions. So maybe a continuance would be best, and then I can get in contact with Ms. Gutierrez.
All right, I will continue this at the request of the defendant. Do you want a bench trial or another status hearing, Ms. Gutierrez?
A status hearing would be great, Your Honor.
All right, Jenna, when would the next one be? You want a Monday?
September 25th.
You want a Monday or a Wednesday at 9 a.m., Ms. Gutierrez?
Wednesday, please.
Okay, we can do September 9th at 9 a.m.
All right, does that work for you? September 9th at 9 a.m. back here by Zoom again?
Yes, Your Honor.
Mr. Storr, does that work for you?
It works, Your Honor. Thank you.
You're welcome. So, Mr. Makhmudov, you will need to be back here with your attorney by Zoom again, September 9th at 9 a.m. Kansas time.
Okay, I will do.
All right, thank you, sir. You're excused at this time.
Thank you so much. I appreciate it.
Okay, now, Attorney Kuhn, you are here for whom?
Jose Del Real, Your Honor.
Jose. Where are you, Jose?
We are on the record in BU 2026 TR 226, State of Kansas versus Jose G. Del Real. Please announce appearances.
Thank you, Your Honor. Joseph Bach appearing for the state of Kansas.
Thank you, Your Honor. Brian Kuhn appearing on behalf of Jose Del Real.
On behalf of?
Does he appear in person or strictly through counsel?
Just through counsel, Your Honor.
Is that approved?
All right. I generally like to have them show up, but you probably don't know that that's kind of my preference. At this time, he is charged with operating the vehicle without registration or with expired tag, an unclassified misdemeanor. It looks like you were present April 22nd of 26, and Mr. Kuhn was present via Zoom at a separate location. You were going to file a written entry of appearance, and the defendant entered a not guilty plea and set the matter over to July 8th. Why is he not here? Why is he not here ready to resolve this today? It's been a few months.
I apologize, Your Honor. We lost contact with Mr. Del Rio. We're trying to reestablish that.
Bench warrant.
And we should be able to reestablish it shortly.
You think? He's
well,
not here
I gave
and he
him
lost
personally
contact.
today's court date. He may think that he hired an attorney, he doesn't have to do anything else, but that would be a mistake on his part. But I can see where he might think that. Mr. Storr, state's response.
Your Honor, I'm on this one, but I see
Mr.
the
Baca?
same. I do see the same notes. We were here on April 22nd. I can tell you, I don't have an objection to one continuance. That's usually kind of my philosophy when they have an attorney and they haven't requested before. But I would leave it in the court's discretion, given it's a tag violation. I wouldn't object if the request is to set it over once more.
If we can set it over once more, I'll ensure that my client is present.
If you can find him.
Yes, Your Honor. Thank you.
All right. All right, Jenna, let's give him one more continuance. So we're using September 9th again?
Yes, Your Honor, for now.
Mr. Coon, does that work for you? September
Yes,
9th?
it does, Your Honor.
All right, this is continued at the defendant's request to September 9th at 9 a.m. And I want the defendant to appear personally at the next hearing. If he doesn't, I'll probably issue a warrant for him, Mr. Del Rio, or consider it at least. All right.
Understood, Your Honor.
Thank you, sir. You are excused at this time unless you have another client.
No, thank you very much, Your Honor.
You're welcome. Thank you. Let's see. Other attorneys on here? Anybody left? Defense attorneys? Okay. Seeing none, let's go up to Dana Helmer on the record in BU 2026 TR 886, State of Kansas versus Dana Michelle Helmer. Please announce appearance for the state.
Joseph Baca for the state, Your Honor.
And defendant Dana Michelle Helmer appears in person and pro se. You are Dana Helmer. If you'd please click on that little red microphone with the line through it so I can hear you. If you're on your cell phone, if you're on your computer, it'll be something different. Are you on your telephone, Miss Helmer?
Look at the camera. Most computers don't have a
Okay.
portrait mode.
Sorry, I got it.
You got it. Perfect.
Thank you.
They're wearing some glasses.
You're here for first appearance on count 1, driving without proof of liability insurance in Butler County on April 14th, 26. Now, if you did have insurance at the time and you just couldn't find it when the proof of it when the officer asked, you can always get proof to the county attorney and they'll probably dismiss that. If you didn't have insurance at the time, you can probably apply for the county attorney's diversion. If you qualify and do what they require, you may be able to get that charge dismissed without having to go to trial, without it going on your record as a conviction.
Okay.
Count 2, you're charged with operating a motor vehicle without registration or with expired tag. It's not one of those, at least in this county, where you can just go and pay the tag and get it dismissed. Although Chief Judge Ricky has made some changes recently as of July 1st concerning that charge, but it is an unclassified misdemeanor. It can be punished by up to a $2,500 fine and a 30-day, up to 6-month jail sentence. You do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply. The officer can give you an application. You're not in the courthouse, are you? All right, so you can apply for court appointed, or you can waive your right to an attorney and represent yourself. Do you want time to hire an attorney, or do you want to apply for court appointed, Miss Helmer?
I can apply for court appointed. I was in the process of moving, so I was working on getting my registration to campus. So, I mean, it's all taken care of now.
All right. Well, if you want some time, you can go online and look at that diversion program. Okay. It's BU, short for Butler County, Kansas, BUCOKS.gov, and then look for county attorney diversion. Okay. And it'll tell you what the requirements are, and you can kind of figure out based on your history and the present charges if you think you might qualify and if you're interested in accepting the terms.
Okay.
If you want an attorney, if you want to apply for an attorney, call the clerk of the district court and ask for an application. The clerk of Butler County's number, are you ready for it?
I am.
It's 316-867-5309. Again, that's 316-322-867-5309.
Okay.
And the diversion again is BUCOKS.gov. Now, if you have a question about that diversion after you go through the online process and look at it, call the county attorney. It's their program. I'm not involved in that.
Okay.
Other than to acknowledge when you're granted. So not guilty will be given to you to buy some time to look into that, whether it be an attorney or diversion. And I'm going to have you come back. Jenna, you want it to be 9/9 again?
Yes, Your Honor, that's fine.
Okay. Your next court date will be 9/9 at 9.
Okay.
If you're diverted by then, you may not have to come back, but don't assume you're diverted unless you hear it from the county attorney.
Okay. I will not, sir, ma'am.
Okay, because
Sure,
you have
ma'am.
to apply, then they have to approve you, and then they send you a contract in the U.S. mail. You sign that and you send that back, and there are financial requirements for both applying and accepting.
Okay.
All right. Anything else, Ms. Helmy, that I can help you with now?
No, Your Honor, I appreciate it.
Okay. It looks like I forgot. Is it Mr. Storr or Mr. Baca I'm working with?
I'm on this one, Your Honor.
Okay, Mr. Baca, it looks like she probably needs to be processed because she's here on a summons rather than an arrest.
I think that's correct, Your Honor.
Okay, Kansas law says, Ms. Helmer, if you're not arrested, then I have to order
fingerprints,
that you get your picture and prints, and so I'm going to set your bond at 1,000 OR. You won't have to put any money up unless you fail to come to court or get diverted, whichever you do. You are going to have to go into a breakout room with court security too and set up a time to get those picture and prints taken.
Okay.
All right. So, Jenna, if you'd please put Dana Helmer and court security in a breakout room, we will be in recess on that. All right. Thank you.
See if we can jump over to Judge
Shane Andrews will be on the record
we need the
in
beard.
BU 2026 TR 26, State of Kansas versus Shane Andrews for the state.
I'm guessing it was
Joseph Baca for the
oversized
state, Your
beard,
Honor.
no permit.
And Mr. Andrews appears in person and pro se. Deputy Caulfield, remind me after this hearing to swing back to court security. All right. Thank you. Mr. Andrews, you are here for first appearance. In count one, the state's alleging you are operating a motor vehicle without registration or expired tag on March 19th of 26.
No beard offense.
This is an unclassified misdemeanor. The penalty could be up to a $2,500 fine maximum. There could be a jail sentence, and it would have to be at least 30 days, no more than 6 months, but probation is an option.
30 days.
On count two, you're charged with failing to check for safe passage before passing from a single lane. That's a traffic infraction. I believe its scheduled fine is $75 and no jail time. You do have the right to hire an attorney, or if you cannot afford to hire an attorney, you can apply for court appointed, or you can look into the diversion and represent yourself. How do you wish to proceed on the issue of representation, Mr. Andrews? You're muted. If you click on the little red microphone with the line through it. If you don't see it, run the finger down the side or the bottom, and hopefully it'll pop up if you're using a telephone.
Ma'am, did you say Amber Rodriguez?
No, I didn't.
I apologize.
No problem. Mr. Andrews, are you on the telephone?
Can you hear me now?
Yeah, I can hear you. Great. Thank you, sir. All right, Mr. Andrews, did you hear what I said about your charges?
I need you to go over that one more time, please.
All right. In count one, you're accused of operating a motor vehicle on a highway or roadway open to the public in Butler County on March 19th of 2026.
Yes.
The tag is an unclassified misdemeanor. If you were convicted, the penalty could be a fine up to $2,500. It's usually much less. And you could also have a conviction. The statute says 30 days up to 6 months sentence in jail is possible. Probation is an option, though. Then in count two, you're accused with failing to check for safe passage before passing from a single lane. This is a traffic infraction, so it doesn't carry any possible jail time, but there is a scheduled fine. I believe it's up to $75. You do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply for a court-appointed attorney, or you can waive your right to an attorney and exercise your right to represent yourself. Whether you have an attorney or not, you could apply for the county attorney's diversion program, where you would apply, and if you qualified, they would grant you diversion and give you some tasks to do to get these charges dismissed and kept off your record as convictions. That's a lot of information in a short time, so let's try to break it down. How do you want to proceed on the issue of an attorney? Do you want an attorney?
I don't believe I need one.
All right, so
I think
you don't.
I think I'll do. I'm sorry. Go ahead.
I interrupted you. I'm sorry. You go ahead.
I think I don't need an attorney. I think I'll try the diversion.
All right, now go online as soon as you can and see if you think you qualify. Do you remember that? Did you get it down? It's BU.
COKS.gov.
Exactly.
Yes, ma'am.
All right. Now, and if you have any questions about it after you've studied it online, call the county attorney about it.
I will do.
Their program. Okay. Jenna, you want to set him over to 99
Yes, Your Honor, that works as well for now.
All right, Mr. Andrews, if you're not fully diverted, you'll need to be back here by Zoom 9/9 at 9 a.m.
Okay.
And I don't believe you need to be printed and so processed because of the lower level of offenses here. But you do need to be back, or you could get a bench warrant for failure to appear.
And that's another Zoom call.
Yes.
Okay.
Now, you can ask the county attorney a day or two before and say, now, am I fully diverted? Well, I have to come to court. And they may tell you don't have to.
Okay.
But if there's any doubt, be here or you'll potentially get an arrest.
Yeah, don't want that for sure.
But if you get diversion, you don't need to be here. So make sure you understand the difference. All right. Anything else, Mr. Storer, on this case? I'm sorry, Mr. Baca?
Nothing from the state, Your Honor.
Anything further from you, Mr. Andrews?
No, I believe I'm good, ma'am.
I believe you are too. You may go, sir.
Thank you.
You're welcome. Mr. Baca, Mr. Storer, are you splitting the alphabet some way like you sometimes do?
Yes, Judge. For the court's information, I'm doing last names A through K, and Mr. Storer should have the rest.
As you know from experience, that doesn't mean I'll remember that, but I'll try to write that down and keep it straight. So, State of Kansas versus Matthew King. You want to take up your case? Click on that little icon, the little red. There you go.
Yes, Your Honor.
We are on the record in BU 2026 TR 924, State of Kansas versus Matthew Eugene King. And that means, Mr. Baca, you're appearing for the state?
Yes, Your Honor. Thank you.
You're welcome. And Matthew King appearing in person and pro se on one count of operating a motor vehicle without liability insurance. Mr. King, that is a B misdemeanor. The penalties require a $300 minimum fine and a maximum of $1,000. There's also the potential for a 6-month jail sentence, but probation is an option. Because this is a B misdemeanor, you can not only hire an attorney, but if you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. You can waive your right to attorney and represent yourself. And whether you have an attorney or not, you may be able to apply for the county attorney's diversion. Well, you can definitely apply, and then you can see if you qualify. If you qualify and you do what you agree to, you can keep this from being a conviction and going on your record as such. Do you wish to have an attorney?
No, ma'am.
Do you wish to waive your right to an attorney?
Yes.
Is anyone making you waive your right to an attorney by any threats or promises?
We're about to bail on Kansas.
No.
Hang on.
All right. And you do understand you can have one?
Yes. Yes, I do.
All right. Then I'll have the record reflect that you knowingly and voluntarily waived your right to an attorney. How do you want to plead to this liability insurance charge, or do you want to look into diversion?
Okay, we're going to bail. We're done. Enough traffic court today. You've scared all of us. We're not going to drive poorly. We're all going to have insurance and everything else. It's going to be good. I promise. We'll be good. Let me find. I need a playlist. There's a save for watch later. It was this one. Judge Molly Hennessy Greenwalt, and we have to go to This is from Josh. 33 minutes, 54 seconds. Hold on just one second. 33:54. Josh says that there's something fishy happens here. One party appears in person on screen, but the other on Zoom, but doesn't show their face. There's suspicion that the attorney might not be real. I'm here for it. Let's check it out. Let's give it just a second for them to queue up as they start this next hearing.
Good morning. Phone number
morning.
5173.
Whoa, Josh.
Can you please unmute? On the telephone, it's a *6.
8675309.
Yeah. Huh. Good morning. Can I have your name, please?
Good morning. This is Donna Smethcamp.
Could you please unmute? And Judge Greenwald will be with you both shortly.
Thank you.
So Donna might not be real. Do we think she's a robot, Josh? I'm confused. One party's here and quite present, taking up the whole screen. We don't even have the judge here yet. I had to jump over to Brandy Churchwell's channel really quickly and say hi. So sorry, I cheated on us. Voice changer, maybe AI. Can you imagine? Okay, GPT. Let's play a game. You are a professional sounding lawyer in a court hearing. The voices you hear next will be the judge and opposing counsel speaking to the judge. Play along in this scenario and respond as a lawyer would in the state of Kansas. Okay, go. Is that what sort of command do you give your chat GPT to be your lawyer? Because this is the next level of stupid if that's actually what happens. I like that green. It's a beautiful, I would say that is a forest green. More than just an accent wall, because he's got 2 walls done that way. But it looks sharp. I think the forest green goes really well with his 5 o'clock shadow. Not a big fan of the cat-friendly door handles, though. Try to keep a cat in a room with a door handle like that, they're out in 5 minutes. But we do have a smoke alarm over the door. That's good. Nice to have that right there. If that door were closed and the fire were outside, the smoke would come through the top of the door first, and that's where it would be sensed first. Very plain walls. Very plain. He's all about business. No party in the back. Reminds me of blue spruce. It does have just a little tint of blue in it. I can see a spruce color there. I'll see your spruce, Teresa. See Josh's comment. Josh says to fast forward for 20 minutes, right? No, Donna's real, but the attorney who is with her might not be. Oh, okay. Nice. We have an invisible attorney. Your Honor, I'm not a cat. Do we have that soundbite?
I'm not a cat.
There it is.
I'm not a camel.
There we go. God, I'm not a cat and I'm not a camel. We have those handles at my house. Needless to say, I got one with a lock and key. They're for someone who has limited mobility or difficulty gripping items for whatever reason. Those door handles are great because you can basically open them with a hook. But as I said, if you're trying to keep a cat out of a room and the cat wants in, if there's a handle like that, the cat's going in. I said, I'm not saying he likes killing people. When did I say that? And about who? Kept getting caught on belt loops. Oh my goodness. If you haven't been hooked by a door handle on a belt loop before, it's an experience and a half. The worst is when you do it on a kitchen counter, like those little knobs that stick out from the drawers in the kitchen. Oh, Those are terrible. Catch you in a pocket, you know, like it's first of all, it can rip your front from back. Your shorts will become, you know, a two-piece. But it also just sort of grabs you at the waist and just chucks your waistline into the granite countertops at high speed. I've done this many a time and have the bruises to show for it. This isn't awkward at all. No, Miss Mary. It's like we showed up early to a dating site, and one person's there. So I'm not sure. He might probably married, not single. Where's the judge? We might fast forward. Josh, do you need me to fast forward a little bit? Let me do a quick check. I'm gonna cheat. 33. She comes on at 39:30. Okay. 39:30. Let's fast forward just a little bit. How far away? Oh, 8 seconds. No, we'll wait. We'll wait right here, guys. I'm not going to do anything. 3, 2, 1. Bing.
And hello, good morning. I'm calling this case, which is Matthew Reed versus Donna Snethkamp. And this is case number 2501153 RGC. We're here for a pretrial today. Matthew Reed, you're here on Zoom. Can you please confirm that you can hear and see me?
Yes, I can, Your Honor.
Okay, thank you. And Donna Snethkamp, you're here also. You're on your telephone only. Ms. Snethkamp, can you please confirm you can hear and see, or you can hear me and Mr. Reed?
She's a call-in.
Yes, very clearly, Your Honor.
Okay.
Yes.
And we are here for a pretrial today. This was a matter that originally was a small claims matter that has been removed to the General Civil Division. Ms. Snethkamp has also filed a jury demand, and you have filed some objections, Ms. Snethkamp, to the court's pretrial scheduling order. Is that correct?
Yes.
Okay, so we have a jury trial has not yet been set. We don't have a date for jury selection and final pretrial, but we can, that will be something to address here today at this pretrial. But Mr. Reed, you have received Ms. Snethkamp's objections to the scheduling order?
Yes, Your Honor.
Okay, so Ms. Snethkamp, what would you like to state in terms of your objections? I know you have issues you'd like to discuss in terms of discovery, is that correct?
Yes, and I have my my attorney here with me, David Naisman.
Okay, well, that's extremely important. I shouldn't be talking to you directly. Do we have an attorney that's filed an appearance in this matter? No attorney has filed an appearance.
No, Your Honor. I have been working with my my state bars to get my documentation, and under the current Michigan law, I need to file with them before the motion is filed with the court. That was done on Friday, and as soon as I get the original signed motion from my sponsoring attorney, that'll be filed with you by at least I would think tomorrow.
Okay, well, you're not a licensed practicing attorney in the state of Michigan right now, is that correct?
That's correct. I'm
okay. So you don't have a lawyer, Ms. Snethkamp. You don't have a lawyer. And
Okay.
I don't know anything about any of what your lawyer has, what you're alleged, or the purported attorney is saying here, because I don't have any of that documentation before me. So,
okay,
Ms. Snethkamp, we're here today for your objections. So nothing about my order that I signed is certainly is not improper under the court rules, and it is typically it's standard scheduling order for a matter like this. So what do you want to object to as to the court's order?
Would you mind if David spoke to this for me, to you?
Yes.
I would mind, because he's not an attorney and he can't appear on behalf of you. And no, he absolutely cannot. And I think allowing him to do so could be problematic for him. He cannot appear as a
Okay.
lawyer because he's not a licensed attorney.
So what was the question again? I'm sorry.
So, Ms. Nethkamp, and I'm looking at my order, paragraph 9. Any party can file objections to its content within 14 days. My order was issued on May 28th. You filed your objections on June 16th. I don't think that they were timely filed.
Boy, we thought they were. I thought that I brought that all in there.
Okay, well, again, they were received by the court on June 16th. So, Ms. Nethkamp, we have a problem in terms of the timeliness of the objections. The court could, of course, overlook that in the interest of justice. But what you're asking, I'm looking at your objections, you're asking that the court allow discovery. And you want all discovery that would be permitted within a reasonable period. The court does not typically order discovery, full discovery like that, nor am I need to in district court.
It paused, and I'm trying to figure out why.
Right now I have 2 unrepresented parties.
There we go.
And the court does not typically order discovery when I have 2 people who are not represented by lawyers. So do you have anything more to say in terms of your objection to discovery?
Well,
and Mr. Whoever you are, I do not want to hear you advise a person that you're not their lawyer.
Well, he was just showing me the paper that this was filed. I brought it in, and it said to file it within 14 days after I received it. So I'm just stuck on that.
Okay, so when did you receive the scheduling order?
Oh, it was probably, I don't have that exact date in front of me here, but you know.
Okay, and I'm saying I can look past the timeliness, but why should I order discovery? That is not the typical practice, and the court rules don't require it. Mr. Reed is not represented by a lawyer. You're not represented by a lawyer. Discovery is typically not ordered in these circumstances.
Well, and I thought that was all included in the filing, you know, some of the objections, if we can go back and go over that.
And I'm looking at your objections and I'm saying, is there anything else you want me to know? Because right now I'm going to overrule your objection.
You know, I'm 70, going on 75 years old, and it all just becomes boggled in my head. I'm sorry.
Okay,
but
so it doesn't seem like we're going to be able to, that objection for discovery is overruled. Your second objection had to do to discover. I think all of these, I mean, if we're having a trial, the court rules require that all exhibits must be exchanged and between the parties in advance of trial, and we will definitely address that. But that we don't need discovery to do that. So a lot of the things that you're asking for in terms of a veterinarian report and billing and something about animal control. I mean, if plaintiff Mr. Reed intends to admit any of that at trial, he needs to make sure that you have those exhibits in advance of trial.
I see. So I don't understand. I've never been, you know, I've never been in a court situation myself before, so this is all really new to me. So
okay, well, you've asked for, I mean, this started as a matter where it was much more easy to navigate for an unrepresented person, and then you removed it to the general civil division where the court rules apply, and now you've asked for a jury trial. So all these things make the case more procedurally complicated. So, but that is your doing, and you have every right to do that, but I can't help you navigate this now. So you've asked for.
Well, I just thought I needed, your help with some counterclaims.
Well, I don't help people with counterclaims. I'm a judge. I'm the neutral party here.
Okay, so what do we do next?
So we go through, and I'm going to rule on these objections. And so far, I'm overruling and denying all of your objections. It does appear to the court that the jury trial, demand for a jury trial was timely made. So we have a demand for a jury trial. So what that means, Ms. Snethkamp and Mr. Reed, is that this will be set for a jury selection. And you both need to be prepared to pick a jury and follow the court rules for picking a jury. And then after that, we would get a date for a jury trial.
Okay, thank you.
And then we also need to, for this pretrial, the court is ordering that all exhibits, so anything, and that would be a document, a photograph, any kind of copies of emails, etc., anything that the parties would wish to admit a trial and have the jury consider, those documents need to be exchanged between the parties, and I'm ordering that needs to happen in the next 2 weeks.
2 weeks, okay.
Yes. So today is the 6th. All exhibits will need to be exchanged between the parties by July 21st.
Okay.
And then Ms. Horn will be looking at the August. Okay, so August 10th is our date for final pretrial. That requires both parties' in-person appearance. And that's at 9:30 a.m. Excuse you?
Oh, I'm sorry, but that's in East Lansing?
That is the East Lansing 54B District Court.
Okay.
And then jury selection is on August 11th at 1 p.m. So, Ms. Snethkamp, I'm ordering that you submit an order to this court that memorializes and puts into writing my order today. 1, all of your objections have been overruled. And
okay.
2,
I'm writing this down.
Okay, and 2, your parties must exchange exhibits by July 21st.
Okay, July 21st.
And then the court will see both parties for final pretrial in person on August 10th at 9:30. Anything further, Mr. Reed?
No, Your Honor, not at this time. So to confirm, August 10th will be a final pretrial. Your Honor, can you confirm the difference between this pretrial and then the final pretrial?
So final pretrial is the day right before jury selection. So the final pretrial requires in-person appearance. So we'll be here at the court. And at that point, the court will review, first make sure all of the exhibits have been exchanged, that the parties are ready to proceed to jury selection, that there's no, any final negotiations have ended. There's no negotiations. There's no possibility of a resolution, and we are going to trial. So that's what that final pretrial. So you'll be expected to, if you think it would be productive, you and defendant can speak before the hearing. You'll both be asked on about those questions in terms of a resolution, and then we'll do all of make sure that the court's orders have been fulfilled in terms of exhibits, witness lists. You'll need to have any witnesses that you tend to call. Those will have to be provided to the court and to the other party, and that you are ready to proceed with jury selection the next day.
Understood. And my last
Okay.
question, Your Honor,
Yeah.
if I may. So the defendant's attorney, currently not a licensed state attorney, he has not filed a Pro Hoc VG, and nor has he filed a motion to appear today.
No.
All of those things need to take place in order for this to move forward on August 10th. Is that correct?
No, I mean, right now, the attorney, I don't have anything before me other than Ms. Snethkamp's, assertion. She says it in her objections, but also on the record here today that she intends to have an attorney, a licensed attorney, appear for her. That hasn't happened. And unless and until it does, she is unrepresented and she needs to be prepared to represent herself at those hearings in August.
Understood. Thank you, Your Honor.
Okay. Ms. Snethkamp, anything further from you?
No. I'm sorry I couldn't figure out how to do the Zoom here. I tried that at mitigation, but I'm just having some problems with equipment. All right. No, I understand. I've been taking notes, so I appreciate your time. Thank you so much.
Okay. Thank you very much. That's all for this matter.
Bye-bye. Mm-hmm.
Hello. Hello.
Hush! I'm trying to have court. Don't raise your voice again. Don't miss the forest for the trees.
Hello. Hello.
Procedural matters, and unfortunately, you have not.
Hello?
You wear multiple hats, sir. Have them send someone with more experience.
Was there, and she moved the camper to this location the day before this happened. As soon as Matthew saw her, he pile drive Rose into the floor and placed her in a chokehold and started punching her in the face. That's the first description. Then later on, she says, when the attack was going on, Matthew heard the homeowner Caleb Gibby. That's when he paused the attack, then broke a broom over Rose's back. That's the contact with the weapon, and fled out of the camper a little after the Caleb, who instructed Rose to go inside the house and call 911. In other words, temporally, it appears that there's a different, although it's an ongoing event that's going on. First, there was Mr. Wiesner's alleged choking, putting his hands over her and putting her in a chokehold. and started punching her in the face. That would be a separate felonious criminal act by preponderance of the evidence of assault by strangulation. Then he broke the handle once he heard Caleb Kitty outside, and then that's when he committed the felonious assault that she ultimately pled guilty to, although he again did not acknowledge touching with the weapon. So the court finds that there is indeed, by a preponderance of the evidence, additional felonious criminal activity that was charged. It did not result and will not result in the conviction. Therefore, 5 points is appropriately scored. Did you have additional objections to the guidelines ranges, Mr. Ziegler?
I do not, Your Honor.
Do you, Mr. Horowitz?
No, Your Honor.
The court's going to count up then the scoring that I have: 10 for OB1, 5 for OB3, 15 for OB10, 12 or 5 for OB12. That would be 35 points total. 35 total points with a Class F crime, PRV level E. 35 would be level 3, making the guidelines range 12 to 24. The attorneys want to be heard on those mathematical calculations.
Sorry.
I agree with that, Your Honor.
Business call came in. This is domestic. It's violent. Involves a firearm.
All right. In terms of the background of the PSI, Mr. Horowitz, do you have challenges to the background of the PSI, the factual circumstances?
No, Your Honor.
Mr. Ziegler, do you?
No, Your Honor. I just have a typographical correction that the court has already hit on. On page 2 under the description of offense, the witness was named as Caleb Kitty. It should be Caleb Kibby, BBY.
Any objection to that change?
No, Your Honor.
The court will make that change. Elocution on behalf of the people.
Your Honor, Mr. Wiesner is before the court for sentencing on one count of felonious assault. This will be his 17th conviction overall.
Whoa.
Among those, he has numerous convictions for theft offenses and several assaultive crimes, including an R&O, a domestic, and an assault and battery. His record does not recommend him well to community supervision. In the instant case, he was in a relationship with Ms. Berge. Following that relationship, Ms. Berge apparently went into hiding, staying in a camper at a friend's house. She indicates in the PSI, or in the information in the PSI, it indicates that she had moved at least once to try and avoid Mr. Wiesner. Apparently, her fear of Mr. Wiesner was well justified in this case because somehow he managed to locate her, entered her camper without permission, and assaulted her. The assault only ended because Mr. Kibbe noticed a struggle in the camper, and upon seeing Mr. Kibbe, Mr. Wiesner fled the scene. According to the victim's version of events, she was strangled, and the defendant broke a plastic broom across her back. While Ms. Berge historically has not been the most credible or reliable witness in other matters, she did appear at the preliminary exam, and she did testify under oath to those facts in this case. She also had redness and abrasion on her face consistent with a struggle. There was a broken broom consistent with a struggle. That's all in the PSI. Caleb Kibbe also appeared and testified at the preliminary exam, and identified Mr. Wiesner as fleeing from Ms. Berge's camper. All of that is to say that the offense itself, as described by the victim, was fairly serious in nature, Your Honor. While the weapon itself, I would admit, and I think this is what Mr. Horowitz was trying to get at, was probably on the lower end of what might constitute a dangerous weapon. The fear the victim felt, or likely felt, having her camper entered by someone she was trying to get away from and avoid, and then being attacked by that individual, that fear was certainly significant to her, regardless of how dangerous the weapon may have actually been. This was also not a crime of opportunity. It's clear from the facts that the defendant must have sought her out with this purpose in mind, to find her at Mr. Kibbe's property and to find her camper there and to enter her camper there. This was not a chance encounter. With the guidelines of 12 to 24, Your Honor, I think a prison sentence is called for. This would not be the defendant's first prison sanction.
What did he just
and he's
say?
had numerous jail sanctions over the years. His history and the severity of the offense do not call for a low-end guideline sentence. If anything, they call for a sentence at the higher end of the guidelines range. Tracking down a specific victim, targeting them for abuse and victimization, with a concerning criminal record to boot, all suggest to me that a higher end sentence is warranted. I also have very little belief that Mr. Wiesner is likely to reform his behavior, given his history. I strongly suspect that when he is released, he will return to the same types of behavior, just as he did from his prior release from prison some years ago, Your Honor. So for all of those reasons, I would ask the court to impose a sentence of 20 months MDOC. Thank you. Mr. Horowitz on behalf of Mr. Wiesner.
Just shy of 2 years.
Your Honor, I think the probably most helpful thing to say on behalf of Mr. Wiesner is to actually point to Your Honor's earlier statements today about your prior interactions with Mr. Wiesner and Mr. Wiesner's prior interactions with counsel. That is to say, it was heated, contested, and Mr. Wiesner was quite simply
belligerent,
a different person. When I began representing Mr. Wiesner, I didn't have any of those issues. And since I've been in court with Mr. Wiesner, he hasn't had any of those issues. When I first met with Mr. Wiesner, I was struck by the fact that I found him exceptionally sharp and exceptionally well-spoken. It's not because he got a new lawyer that makes the difference. It wasn't that he had Mr. Trevis before that made the difference. His medication has been switched. He has been medicated differently in the jail. That medication has greatly enabled him to conform his actions to what we all find acceptable. He's even keeled. He's able to exercise patience. He's able to listen to allegations against him that probably don't feel good to hear and isn't reacting to them.
He's a good guy when he's
he's
sedated.
reacting to them, certainly, but not reacting inappropriately to them. Frankly, he's doing great, I think. And I think looking at the contrast between what the court's seen before and what the court's seen over the last couple of hearings shows that, one, he's capable of reform and rehabilitation, but two, that a lot of what he's been going through is a result of intellectual and mental health difficulties, probably long-standing, and that this medication is really necessary. And without it, he just doesn't have the same, I guess, intellectual and mental health opportunities that the rest of us have. So looking at him from before to today, I think is a huge contrast. And I think that recommends that the court should not impose the highest sentence it can. I think the court should consider, especially given the severity or lack thereof of the dangerous instrument involved in the sentencing offense, that the court should consider imposing a sentence of 12 months, a local jail sentence. That said, we acknowledge Mr. Wiesner's record. We acknowledge that it's long. I believe in between Mr. Wiesner's last prison sentence, he had a strong period immediately following that on supervision of succeeding on parole, probation, and was out, I believe, 7 years or something like that. So I think when the stars align and when he gets his medication adjusted correctly,
stars align, he's a good guy.
He's totally capable of doing what we need him to do. So with that, I'd recommend the court impose a sentence at the low end of the guidelines. Thank you.
Thank you, Mr. Horowitz. Mr. Wiesner, was there anything you wanted to tell me before I impose sentence today?
Made a mistake and got to deal with it. Oh, don't I know what to say? Other than sorry.
Sorry.
Thank you, Mr. Wiesner. I appreciate that.
Heartfelt.
I appreciate that you understand you made a mistake, and I do take stock of the fact that this situation today, in terms of your reaction to it, is starkly different than you have been in the past. And I credit you for that. That's a circumstance that I frankly didn't expect, because you and I know we've had some history of difficult interactions. And so I credit what your attorneys claimed is that that is a result of a couple of different things. Probably A, it's taking responsibility, you taking responsibility for the fact that you're here. You took that same responsibility during the plea by acknowledging that you were guilty and wanting to take advantage of that plea agreement and acknowledge it. And you clearly and unambiguously told me you were guilty. I didn't necessarily expect that either. And I say that only because that taking of responsibility is an important factor to the court in assessing what's a fair sentence. In those situations where I find that a defendant isn't taking responsibility, it makes me less likely to think that they're going to be capable of rehabilitation. And so the fact that you are taking responsibility for your wrong actions is somewhat significant to me because I didn't expect that. I think that it's fair for you as well to contest the factual information, meaning I don't penalize you for contesting the factual information that I ultimately determined, or that you disagree whether or not there was a touching by a victim of a weapon, or that you disagree that there was a strangulation. Those are all fair things for you to disagree with. And you didn't even touch on them. Your attorney did as an advocate for you. I don't hold that against you in any way. Those are important distinctions, and they have an important impact on your sentencing guidelines as well. Your guidelines were 10 to 23, now they're 12 to 24. So those things matter to me as well, and I don't count those against you. I did find those facts in against your favor, but I don't hold you any ill will because you contested the factual accuracy of those claims. When I look at the background, the most striking thing to me is that you have now your 9th felony conviction as of this conviction and 8 prior misdemeanors. 4 of them prior were assaultive. Those assaultive convictions really only started to happen when I looked through the PSI no later in life. You had a lot of theft-related offenses. I'm not minimizing those, but to the court, the assaultive convictions are the most concerning because they reflect on the seriousness and the danger to the public and that these type of circumstances indicate. And your attorney's right, even though I think it's very serious when you assault somebody with a weapon, touch them with a weapon, by preponderance of the evidence, assault them by strangulation. The severity of the weapon involved, it also is a consideration. It's not a way to minimize the offense, but it's a way to take into account the fact that there are many different types of weapons that can be involved in assault. An assault with a gun is more serious and therefore deserves a stronger punishment than an assault with a different weapon. Again, that's not to say that this assault was not severe. It appears to me to be very severe. So a severe reaction is in order, but I think that severe reaction can also be tempered fairly with your responsibility taking, the fact that you're sorry for making these bad decisions again, and altogether that points me in the direction that I think I need to be in, which is a sentence within the guidelines range. It happens to be a sentence within the guidelines range of the original guidelines. It wasn't much of a change again. I think an 18-month sentence for this type of an offense, for this type of individual, is fair in proportion to the circumstances, and that's what the court will issue is an 18-month minimum prison term up to a maximum of 4 years. You do have credit for 191 days that you previously served. The court will order the crime victim assessment of $130, court cost of $325, attorney's fees of $350, and a state cost of $68. Those fines, costs, and assessments are due today. By state law, if you don't pay them within 56 days of today's date, a 20% late fee gets added on. Mr. Wiesner, you do have the ability to ask for leave to appeal. You can go through those appeal rights with your attorney. The top copy you sign just indicate that you got the rights. The bottom 2 copies are yours. If you wish to ask for leave to appeal, fill those out in their entirety and turn them back into the court.
So we'll serve a year.
Going over the appellate rights with your client. Do you have anything further for today?
No, Your Honor. Thank you.
Mr. Ziegler, anything else today?
No, Your Honor.
He'll serve a year for that. And he's going to prison, not jail. We're going to do a quick hop here. We've been told that Judge Simpson had a little bit of a spicy moment. Judge Cedric Simpson, YouTube. There he is on the last one before he went to break. There it is right here. Let's back up a little bit and see what happened before he went to break here. Oh yeah, I can see it's
your hand.
This one.
Yes.
What time, do you know how far back we have to go, Josh?
Well, I don't mind. I take it, Mr. Cook, that's why you are here today.
Let's back up a little bit. See when he gets the folder. He picks up the folder when the file's handed to him.
Yes. All right. Thank you.
Yes, I
We'll
did.
see you.
You want me to call
All
the
right.
provost
See
defender's
you at the
office
22nd.
or the prosecutor's office? Okay.
Okay.
All
See
right.
ya.
Thank you.
Bye.
Court calls the case
hang up
People
now.
versus Pauline Schoener.
Josh said last 35 minutes or so. We are. Colleen's going to be a different one.
Doing that hearing today.
Prior to making any form of a bond reduction, the jail was asking an order for remote participation for an order from this court. I did attempt to send proposed orders to the court, but there is an issue apparently with my emails and not just being received through this court. So I will correct that immediately. I don't believe that I printed.
Okay, so let's go back here.
Review the PSI. We have no additional corrections, insertions, and deletions to the content of
3 days in jail suspended.
Okay,
when
sorry,
can
guys,
you
we're
get
trying
that
to find
paid,
this
ma'am?
point.
I can put
this is
it
the
on my
last one.
charge today.
Okay, all right.
You
Get that
take,
paid
you take
today
Visa,
and then
Judge?
Put this VIP to move on.
Thank you.
Well, take care.
You too.
Court does call the case People State of Michigan versus Nicole Henderson.
Nicole Henderson.
Morning, Judge Simpson and staff. Nicole Sadi. I represent Ms. Henderson, who is coming up to the podium now.
Your name?
Nicole Henderson.
Go ahead, counsel.
Your Honor, so this morning I did file an emergency motion in person regarding the bond. I'm not sure if you're able to hear that in the moment or schedule an immediate hearing on it. I was informed that I tried to communicate with the court. Ms. Henderson had secured Mr. Statman's services to do a substance abuse assessment. We understood from what you said from the bench last time that you want to read the assessment prior to making any form of a bond reduction. The jail was asking an order for remote participation for an order from this court. I did attempt to send proposed orders to the court, but there is an issue apparently with my emails and not just being received through this court. So I will correct that immediately. I don't believe that I printed a copy today. I believe you have one electronically. If you're willing to hear.
I back up a moment, counsel. You sent an order to the court today?
No. Yesterday, and I had also sent a request for a remote hearing on Monday, but I showed Ms. Wielding my emails. My emails were sent, they were not received. I did have a hack event last week through one of my email accounts. It was a party invitation that was not a real party invitation. I never should have clicked on.
You clicked on a
I thought I had
invite.
secured the emails, but I believe Ms. Wielding didn't receive them. I didn't get a bounce back, so I'll have to correct that issue. But I wanted to make you aware that I've attempted some.
Don't click on the
And then
party
you've
invitations,
indicated that
folks.
you filed an emergency motion.
I did a bond motion, Honor.
Is that this one?
Yes, it is.
That means what's in your hand.
This one.
Yes.
Well, I don't mind. I take it, Mr. Cook, that's why you are here today.
Yes, Your Honor, we're here for a pretrial as well as a bond review hearing. I was served a copy of that motion this morning. I was able to read through it. Most all the information in the motion, I believe, was already placed on the record, so I was already aware of all of this. So I'm ready with it. On the motion, if the court wants a response, I'm fine with doing that hearing today if the court's inclined to do so.
All right. Well, go ahead, counsel.
My thought would be, as the court indicated previously, we want to see substance testing. Obviously, Ms. Henderson has this OWI case, the out-of-county OWI case, as well as the pending malicious destruction matter. My concern is making sure that she gets substance abuse counseling, and from what I'm hearing, it sounds like that being done in custody is creating additional hurdles. I don't know. I spoke briefly with Laura. She indicated she may have a different individual who could do a substance abuse testing in custody. I'm not sure if that would be faster than for Mr. Statman to do a remote hearing with this defendant. I don't know the time frame on that, but I want to make sure that whatever way we move forward, so expeditiously to get her started with that counseling as soon as we can. Obviously, I think, as the court indicated, I don't know if it was last time or the first time that this case was up, there's some pretty serious health concerns for this defendant if she were to be released, and concerns about what she might do to herself with her substance abuse and whether or not she might harm or kill herself or someone else in the process of that substance abuse. So I just want to make sure that we are addressing that adequately before release. And I would be fine with whatever method that is, whether that's with Mr. Statman or with the individual that Agent Polaris stated. I'm happy to do whatever legwork I need to do to make that go faster. If there's an order for that remote counseling, I have no objection to that order, but I want to make sure that we're doing that before we consider release.
May I respond?
Go ahead.
Thank you. So the issue with the time is that Ms. Henderson, unlike some of the indigent defendants I've represented, actually has some excellent resources that she can use. And they are, I'm sure that Your Honor has heard this, but I would like to emphasize this. Now, Ms. Henderson, it is alleged that she has an issue that is with alcohol. And we know that withdrawal alcohol, although she's been incarcerated for more than 30 days, we know that there were physical effects and psychological effects that go along with getting rid of that addiction. The type of position that Ms. Henderson has allows her to go in without there being any harm to the job that she's held, which supports herself and her daughter. She will be indigent if she doesn't have another form of work or full-time employment, and it is very difficult when you're facing felony charges to be able to find employment, as I'm sure this court is aware. Now, this particular program she goes into, and she also suffers additional consequences once she's assessed. They do a professional assessment. That professional assessment makes recommendations. Ms. Henderson has to follow the recommendations, and if she does not, then her job becomes endangered. Her security is in jeopardy. This is all shared with her work. It's my understanding that all the programs are 6 to 8 weeks long. They're not just a 30-day program, that the assessment may very well put her inpatient. They put people inpatient if they are assessed to be a form of threat to themselves.
This is the program through General Motors.
The program through General Motors. There is an issue with Mr. Statman being able to assess her level of addiction, but those resources go away if she loses her job. This program hooks her up with.
But she's on leave, right?
Not for this week. This week is the week where it becomes, her leave becomes, she's expected to be back at work this week. Her leave is ending.
When does your leave end, ma'am?
I was supposed to return back Sunday night, July 6th.
Got it. All right. Go ahead, counsel.
Thank you. The truth is, Your Honor, while it is true that, it's appropriate for this court to weigh public safety concerns, even concern for my client herself, and what could happen, while that's appropriate, there's far greater harm that will happen here. It's not just a potential if she is incarcerated and unable to continue her employment. We are requesting that you put in an order that she immediately be assessed and follow the assessment done by the professionals. We can have Mr. Statman assess her, but he does not have access to those private services, which are actually, if I'm going to be real, they're superior to what community centers can offer Ms. Henderson if she were to lose her job.
I understand it. I get all of that. Ms. Polera, have you talked to Ms. Polera, my probation officer, regarding getting her assessed?
I have not, no.
Your Honor, I know, I just spoke with Mr. Cook this morning. He was telling me that they were waiting for someone to get assessed. I had someone else who did an assessment for me at the jail. However, there is a cost to it. So if she doesn't have the funds, I don't know that could happen.
To pay for
and that's where it's a catch-22, because if she does lose this employment, she won't have the funds for court costs.
I get all of that, counsel, and that's why I put this actually on a non-sentencing day, because I was hoping to get the assessment, fashion terms and conditions of her release so that we could get her out of here with something in place. But right now, as I sit here, I don't have anything in place. I'm at the exact same point that I was the last time we were here.
I need a written order, if possible, Your Honor, if you would consider it. She did pay Mr. Statman. Mr. Statman's schedule allows for a remote assessment.
Paid him
Yes.
already?
Yes, he's been paid. It allows for remote assessment. The jail needs an actual written order from the
Well,
court.
then give me an order. I mean, if I get an order, I'll sign it. I wanted her assessed.
So that's where I'm so sorry that I did email one. Those are the emails that were not received. I would have printed one for you this morning. I can get one faxed if my email is an issue to you. I can fax the same email I attempted to send with the proposed order.
Did Mr. Statman indicate how fast he can get to her if I can get an order
By Friday?
by Friday?
That was my belief. He is making time for her. He waited yesterday, and I was waiting for communication from the court that you didn't receive.
All right.
Whose fault is that?
The only thing
Not
I
the
would
court's.
add, Your Honor, is looking at the services that Agent Flora referenced, that at least according to their website, they can do within 48 to 72 hours of booking. It's a $200 cost. I understand the defendant may not have that, but in case something falls through with Agent or with Mr. Statman, I believe that might be another quick turnaround that we could hopefully get through by the end of the week if that's an option.
Okay. I just need to get her assessed. I just want an assessment and a report given all of the circumstances in this case. How complicated can the order be for Mr. Statman?
It wasn't. It was a one-page order that I proposed.
Then can
Your Honor, would you like me to call Mr. Stanley?
if you would. My problem is that I think from the jail's perspective, I just need an order to get so that the jail will make the proper arrangements so that Mr. Statman can see her.
That's what they told me, yes.
And the place that you have is a 48 to 72 hour turnaround
Correct, Your Honor. And
from the time that they
receive the referral. And I could contact her. I mean, I don't know if it would be up to that. According to the website, they have a fast track one. So I don't know if the assessment price would be less if it wasn't like emergent. That would be a conversation that I would have to have with her. But I do know that she has gone to the jail or done things remotely via Zoom.
Got it.
And has accomplished an assessment.
All right. So the problem's going to be I'm now here at Wednesday. Her leave ended, you said Sunday.
And I know that this court is aware you could put her on an alcohol tether. She does have court in Shelby Town.
That has counsel. That's always been an option. The problem is the circumstances of this case, and I am doubtful to. I'm not changing my mind on that. I mean, she needs help. We can fashion something so that the public's not at risk, she's not at risk. I mean, the bottom line reality to it is that little girl that was here the other day, her daughter, I can't in good conscience let this defendant out where she may be traveling with that child, if no other reason.
Your Honor, I do not have discovery. I emailed discovery for discovery. I haven't received it yet. I just gave Raymond here a copy of the email I sent over to I believe. Oh, I will give it to you. Sorry about that. I sent over, but I am unaware of any allegation, and please correct me. I am unaware of any allegation of her being inebriated in the car with her child.
Counsel, that's not my point.
Uh-oh.
I understand your concern, and I understand that we see things that happen, and you need a time machine. Basically, I understand that. I really do, Your Honor. And I really do feel that you're coming from a place of concern. I honestly do, but her daughter is in danger of losing, they're not married. She's been incarcerated. She's the one that has full-time care and custody. Her daughter doesn't need health care from the state. They don't need food stamps the way that things stand. So our concern is about what actually happened.
Counsel, she's got a prior, a pending, and another pending. She was a .235 in this case. She was making comments that were, and I'm not necessarily qualified to say this entirely, but were of a suicidal nature of what she would do to herself, and that she just didn't care. That's where she was.
And she can be released into a treatment program with doctors and still get a substance abuse assessment instead of the detention where she's not receiving services.
You know what? I'm done arguing about it. I asked that something be done so that I could fashion something or be assured to let her out with as least risk as possible to herself or to the community. I haven't gotten that.
Your Honor,
now I'm here today, counsel, trying to figure out how to make it happen. And so we can keep going around and around. Well, you can keep going around and around because I'm stopping. I'm not going around and around about this. I told you what I wanted. I told you what I needed to try to assess it, to let her out safely. I will do that, but I need it.
Your Honor, may I have a written order denying the motion?
If you get me that order, I'll deny your motion, but get me the order that it gets her treatment, counsel. I don't know why this is so hard. Get the order.
May I explain?
Get the order.
In my email box, your court didn't. And
get the order. I'm done. Take her back. I'll call the case back out, but I'm not going around and around. Get me the order.
I did.
I have,
go ahead.
I'm going to on the record address this so that it's clear. I have proof that I sent the order.
I don't have it, counsel. So that means we can't do anything.
That is correct.
I'm not saying whether I believe you or not. I can't do anything. I can't keep going around and around about this. I need an order so we can get her assessed. Everybody here wants her assessed as expeditiously as we possibly can. But I'm not going around and around about it. Let's just get it done.
Just send the
Ms.
email.
Polera, what were you going to say?
Yes, Your Honor. I just wanted to update the court. I did just speak with Mr. Statman. He indicated that if he has the order, he can do it as early as tomorrow at 10 a.m. He tried to do it.
Get me an order. Somebody. I don't care if it's handwritten. Get me an order, counsel.
Yes, Your Honor. I attempted to. And I will make.
Oh, I hear you. Get me an order. Get a piece of paper. Write an order so I can get her assessed.
Oh, yes.
Right now. I'm done. Step away from my podium. Court is standing in recess.
Why was she arguing? Why was she arguing that she had tried to send it before? What? The judge is like, I'll sign it. I'll do it. Yes. I have to have something to sign. Give me the paper. She's like, well, I tried to send it to you. Well, I don't have it. So if you can send it to me, I'll sign it. We'll do this right away. Everyone's on board. State, defense, client, the individual who do the assessment, the judge. They're all on the same page except this one attorney wants to fight over the fact that because she clicked on a fake email and got hacked, her email isn't going through. And he says, I don't care. Handwrite it. Get a napkin, write on the back, this motion, I will sign it. It will happen. We'll file it. Oh, man. The judge, she was arguing for the same thing the judge was asking for, but she wants to make a big deal of the, I already tried to send it, and it didn't go through. So what do we do now? Well, I'll let you think about it. You tell me. You're only hurting your client while you sit there and fight about it. There's some parole hearings going on right now, which we haven't been to in quite a while. Louisiana Board parole hearings. And I think if I can go back just a tiny bit, Louisiana Board patrol hearings. There it is. Up right there.
That year.
Hang on 1 second. We're going to back up just a tiny bit because there was one that had just some great personalities showing up. Just 1 second. Here we go. All right. I don't know what this one is about. Hopefully it's not a case that we want to bail on. But I see Steve Prater's in the house. We're going to go to Zoom feed in just a minute. There we go. Okay, we have a puppy. We have Jack Lubin jamming to his headphones. When does court start in Icelandic time? I can tell you that court starts in 2 hours. 2 hours, Tyler Robinson hearing. We'll be live with the Tyler Robinson hearing. And we'll portal over to it. We've already got a thumbnail up for that. The portal's already built. When this is over, we basically are just filling some time doing a little bit of court hopping around some of our favorite places to watch court proceedings. Oh, Jack has gum.
Okay, would you state your name and DOC number for the record, sir?
Ryan Hunter, 461111.
Okay, Mr. Hunter. We are now at the Orleans Justice Center. Time is 10:11. We're here today for your revocation hearing. My name is Pete Freeman. I'm the acting chair. Along with me is Mr. Steve Prater and Ms. Cheryl Renatza. Mr. Hunter, did you get a parole questionnaire?
Yes.
Okay, did you sign that paper?
Yes, sir.
And you realize you're not eligible for appointed counsel. If you wanted counsel, you would have had to hire it.
He's got money.
Yes, I have a lawyer present.
Okay. Okay. Public Defender's Office. Okay. And so are you ready to proceed today?
He has a public defender?
Yes, sir.
Okay. Your case has been assigned to Ms. Renatza. I'm going to turn it over to Ms. Renatza.
Okay, thank you. And I see Mr. Lubin, you're the counsel this morning.
Yes, ma'am.
Okay.
It's nice to meet you. Thank you all for having me.
Yes. So I'm just gonna, I know he was here in April and we had a condition number 4, criminal activity he was found not guilty of. So I'm gonna go over what the remaining allegations are for the parole conditions. Mr. Hunter, I'll ask you to enter a plea of guilty or not guilty, and then we'll talk with everybody. I see you have your client advocate here, and we'll just kind of see what everybody has to say before we make a decision.
Yes,
So you
ma'am.
are accused of violating condition number 2, and that says that you failed to report to your parole officer when ordered, as evidenced by the fact that you failed to report on October 14th and November 6th of 2024. How do you plead to that?
Guilty.
And then we have condition number 3. You failed to live at the address provided to your parole officer as evidenced by the fact that attempts were made to contact you at your residence of record in October, on 3 different dates in October 2024. No contact was made. How do you plead to that violation?
Guilty with a statement. If you don't
Okay, and we'll take that in a minute. Last one is condition number 10. It has to do with your fees. It says you were behind $630 in your supervision fees.
Yes, ma'am.
So what's your plea?
Guilty.
Okay. And it's my understanding with regard to well, tell us why you didn't report as you were instructed to do on those 2 dates I mentioned.
I was evicted.
Why didn't you
And
report to your officer?
I was evicted and homeless.
But that doesn't answer my question. I mean, I understand. I read the packet. I know that your girlfriend was evicted from her apartment. That the fact remains that you didn't report to your officer.
No, ma'am, I didn't. That's almost impossible walk from where I was living on the street at the time.
Okay. And the same would apply, I suppose, for the other one about not living at your address because of the eviction. I understand that.
Yes,
ma'am. So it's my understanding, and you've been in jail almost a year, well, over a year now.
Yeah, over a year, ma'am.
Okay. It's my well, I'm gonna turn it over to Mr. Lubin. I would like to hear what you have to say and the client advocate as well.
Yes, ma'am. Thank you so much for inviting me to speak. I am in a jury room right now in Orleans Criminal District Court. So if my connection cuts out, please just make a funny face at me. I am speaking as Mr. Hunter's attorney. As you mentioned, Mr. Hunter's been incarcerated for over a year, and over that year, I've gotten to know Mr. Hunter quite well. Now that this is presumably my final act as his attorney, I can also say I consider Mr. Hunter a friend, someone who I trust, who I would trust with my loved ones, and someone who hopefully I am going to take up on his promise to take me fishing one day. I was mostly here to speak about the criminal charges, which resulted, as you mentioned, in a not guilty. But I think that those notwithstanding, the story that led to those also explains a bit of the other violations. As Mr. Hunter mentioned, Mr. Hunter experienced a period of homelessness, both he and his fiancee, Miss Hunter, who's on the call as well. And it was really that stretch of homelessness that set this entire sequence of events into operation. Mr. Hunter had been, until that point, my understanding was quite compliant with his parole officer, and not just compliant, but on top of his game, so to speak. One big thing I spoke about with Mr. Hunter is specifically the criminal charges stemmed from the fact that Miss Harden does, or at the time did, own firearms. She is not a convicted felon. She was legally permitted to own firearms. But that was something that Mr. Hunter went over with his parole officer. He wanted to make sure he was protected.
Oh, and he cut out.
The advice he got was to keep them in storage, and unfortunately the eviction led to them losing, among other things, their storage unit. So the criminal case was one of a story of homelessness, but I think all of this is as well. Mr. Hunter obviously fell behind on his fees. He certainly was not able to keep his address stable because at the time of these allegations, Mr. Hunter was basically splitting time between 3 separate addresses. But all of that was shorthand for saying he was living in his car. He was able to park in certain garages or driveways, take showers in exchange for work cleaning up houses. He was cleaning up some truly rundown and sad condemned houses. And Mr. Hunter and Miss Harden were living very hard. I think Mr. Hunter would be the first to concede that during this period of hardship, he skipped some steps.
Attorney's doing a good job
on the 2
for
mentioned
him.
occasions, and he was not able to stay on top of the address. And that's something that this last year has given him a lot of cause for reflection for. I think the main theme in my conversations with Mr. Hunter that have come across from speaking with him are that obviously at this point, the criminal charges have been closed. Mr. Hunter has been found not guilty. The jury, having spoken to the jurors, the jury found conclusively that Mr. Hunter was never in possession of a firearm. And yet, Mr. Hunter understands that there is a different set of expectations when you're on supervision. It is not just staying within the 4 corners and the black letter of the law. It is also taking care of the affirmative responsibilities that you must take care of in order to continue to earn back your freedom and to prove to the board proof to society that you are someone who is able to be a productive member of society. I can say with absolute and full confidence, I believe Mr. Hunter is a productive member of society. I believe he can be. I believe that the facts of this case speak to elements of his character that really put him above and beyond. You know, these allegations ultimately stem from the fact that Miss Harden accidentally, while handling a very unsafe firearm in the middle of the night in pitch black conditions, discharged the gun and shot herself in the neck. And Mr. Hunter's first and only instinct was to save her life, to apply pressure to her wound, to call 911, to do everything that he could to make sure that she got in an ambulance safely and was taken care of. That's not just because Mr. Hunter loves Miss Harden, but that's because that's the type of person he is.
Can you wrap it up, sir?
Oh, yes, I'm wrapping up now. I'm going to defer to Mr. Pierce about the release plan that's been put together for Mr. Hunter, because I think this is a man who's going to succeed with supports. I defer to him on the supports. All I would say is that I do pray that the board finds it suitable to give Mr. Hunter another chance. I feel extremely confident he won't do y'all wrong.
Like the argument he gave
Mr.
for his
Pierce?
client. That was awesome.
We did get your letter. It was late yesterday. I have read it. I know your plan is New Beginnings, Behavioral and Family Services. Can you just summarize that all for us, please? You're on mute still, I think.
Still muted, wasting valuable board time. Mr. Prater. Sorry, say his name and he looks up.
I still can't hear you.
Poor inmates, like, come on, you guys. Yes. No.
It shows you're not mute. Are you connected to the audio?
Or volume.
It's not the volume. The volume is your speakers on your side. Possibly the mic gain or something.
Make sure your volume up on your speaker.
Turn your volume up. Maybe that'll fix your microphone.
That's still not.
This sucks for Mr. Hunter. He's got 5 minutes before the board.
While he's trying to figure that out, Miss Lydia, could we hear from you?
Oh.
Can y'all hear me?
Yes, ma'am. Tell us what the
they're driving.
The living situation is now.
I am living in South Carolina. I have our dog, clothes, food. I live with my mother. My mother is she's not taking care of me. I do have a job. She does take care of me, but I'm predominantly working, also events and stuff like that. I've been drug-free since everything happened. So last year, July 1st, I have a better life. I'm living well.
Good.
And I just want him to come home.
So would home be in South Carolina?
Maybe I have places in Louisiana that we can stay in, but we discussed that we do need a change. Me and Mr. Hunter have talked about a change in scenery from New Orleans to get a better life.
It's recorded on a potato. Sorry.
Thank you. Mr. Pierce, did you get it? Looks like he's frozen now.
Yep. Jack Lubin is ready to almost dive in.
As
Here he
Mr.
goes.
Pierce is assembling, I promise I'll be brief, but one thing lost in the audio quality, I think, from Miss Harden is that Miss Harden's currently living in South Carolina. She is, however, expecting the birth of her first grandchild, which is going to prompt a temporary move back to the New Orleans area. But her ultimate hope is either if Mr. Hunter's reinstated on parole, his parole might one day be transferable to South Carolina, or in the alternative, that Mr. Hunter completes his parole period in Louisiana, but the long-term plan is to move to South Carolina because Ms. Harden has found that the living conditions are more suitable up there.
Okay, good.
Mr. Lubin's doing a great job.
Well, I don't know about Mr. Pierce. I'll tell you this. Let me just talk to you, Mr. Hunter.
Yes,
Are you
ma'am.
has Mr. Pierce spoke to you about the New Beginnings program?
Yeah.
How do you feel about going through that program?
That's what it takes. I'm willing to do whatever it takes.
How are you going to support yourself when you get on the street?
Oh, I'll be able to get a job. I won't. It's hard to work when you don't have nowhere to stay.
Where are you going to stay?
I'll be staying in Slidell.
Where?
At a cousin's house. Gun free too.
What's the address of your cousin?
My fiance has that address. She's on Zoom with us. The exact address.
Yeah, because that's gonna have to be approved before we do anything.
All right, Mr. Pierce, are you?
Can you hear me?
I can. Can you
Finally.
just summarize the New Beginnings for us?
You can hear me?
Yes, sir.
Okay, yes. The New Beginning is a program where it would help Mr. Hunter with his family situation and his depression, perhaps, maybe, and grief counseling. And we also have a program that's going on with at the Delgado Community College, where he can perhaps get acquainted with job training. They have a little program going on there where we can assist him with in getting job programs in forklifting. And it's a free program where they'll give him a certificate certifying him as a forklifter. This would help him with the job placement program. I failed to include that in my my letter because this is something that just started, just something new. And we are trying to help Mr. Hunter get started on this. And I will help him personally. And we ask that you all do not revoke. Mr. Hunter been doing pretty well since he had been on parole. And these things occurred in his life where, he had a bump in the road. And I'm sure after being incarcerated for a year, he's learned that this is not the right way to live. Thank you.
Thank you. All right, Mr. Chairman, that's all I got.
I have no questions.
Let me ask you one thing, Mr. Lubin, you maybe can tell me. You may mention the fact that he was doing well on parole before this, and that's the same thing that Mr. Pierce said. How long had he been on parole before the allegations of missing?
Thank you for the question, sir. My understanding, and some of these forms are pretty opaque for me to read, is that it was roughly a year of parole time. But Mr. Hunter, please do correct me if I'm mistaken about that.
July 3rd of 2024.
July
You
3rd.
got on
That's when he got
parole.
out. Yeah.
You had just gotten out, correct?
Yes, I believe so.
Okay, so we don't have a history of having done good on parole like
He
we
stayed
said
out
before.
5 months. The warrant was issued on November 7th, 2024, and he got out in July 24.
Okay, he got out in July of 24.
Right.
And by the first day, and by the 14th
By November, we had
of October, they couldn't find it.
correct.
Okay. I just didn't want that to go over as having had a number of months or years of good activity on parole. And the fact of the matter is he never done good on parole. And so that's what kind of bothers me about this. I want him to understand that you got to make an effort to contact your parole officer. You stayed in contact with your girlfriend. and you stayed in contact with other folks, I'm sure. And if you can do that, you can stay in touch with your parole officer. I mean, I just don't want you to think that we just, you know, living on a load of goats or something up here and don't take notice of what's being said.
A load of goats.
Anyway, that's all I wanted to say before we vote.
Excuse me, can I say something?
Sure.
I'm reflecting on what Mr. Prater is saying. That's true. I mean, a lot of guys come out of jail and go straight to their family members without a reentry plan. And that's what Mr. Hunter's problem is. He didn't have a plan when he came home, and he was placed on parole. He didn't have anyone to help support him that know about re-entering into society after spending so many years in prison. And this is where I'll come in at, and I will do whatever I can to help Mr. Hunter stay on track. Thank you.
Okay, well, thank you, Mr. Pearson. And you're exactly right, and we appreciate what you do and what you're saying that you're going to be able to do. I just wanted to point out to the board and to everybody that's listening that I don't know, if something's told to us wrong, I don't want people thinking that we just accept it.
Right.
Okay, is the board ready to vote?
I am.
Okay, Ms. Renatza?
All right, Mr. Hunter, I agree with Mr. Prater. It's your responsibility to report to your parole officer. It's not up to him to try to find you. However, I'm willing to give you a shot. I think that the plan, the New Beginnings Behavioral and Family Services, is a resource you can use. Mr. Pierce is willing to help you through that process. My vote today is going to be do not revoke, issue a reprimand, add special conditions that you do participate in the New Beginnings Behavioral and Family Services program. Whatever program they say you need to do it and complete it. And then also enroll in that Delgado job training program.
Yes, ma'am. Thank you.
And for the first 60 days after your release, you are to report to your parole officer weekly.
Yes, ma'am.
Okay, that's my vote.
It's W-E-E-K, not
Okay,
W-E-A-K.
I concur with that. I just want everybody to understand how serious we are about doing what you got to do on parole.
Okay, so I also concur, but I do not think you should be released until the probation officer gets to track out that address and make sure it's suitable. So get that address to the probation officer. Your wife needs to get it to them, and as soon as they check it out, if it's good, they'll release you. Okay. Good luck to you.
And I would note for the board, I am in receipt of that address because this is a public stream to YouTube. I think what I'll do is get in touch with the probation officer or the parole officer directly. But I am in receipt of the address.
Okay. If they get that checked out, would be good. Okay. Good luck to you.
Thank you, board.
So he's approved. Gets another shot, doesn't get revoked, which is a good deal, I think, for him. I hate seeing somebody get caught in the system because of poverty. I'm not talking about poverty leading to crime. I'm talking about not having the money, not being able to travel. You know, you've got a place you're staying. You can't walk the number of miles needed. You don't have a cell phone to check in. Oh, you didn't check in, back in jail. How does that help anybody? How does that, first of all, I don't think it has anything to do with keeping people safe. Anyway, love that he gave him another chance here. He needs to do better, for sure. But let's see. Judge Ricky's doing something, but it might be a custody issue. Yeah, I'll get off my soapbox now.
Marriage of Jody Doherty and Joshua.
It's a divorce issue. We'll bail on that one. Don't need to watch the divorce stuff. I think that's done. Let's see who else is live.
I don't disagree, and I've known Ms. Hiddle, and I've represented Ms. Hiddle quite a few times over the course of her lifetime. And
Mr. Seeger, you need to speak up.
sure, yeah, I'm sorry. Your Honor, I've represented Ms. Hiddle quite a few times during the course of my legal career. I've represented family members. I recognize that she struggles with substance abuse. It has caused a lot of problems for her. Historically, it has caused a lot of problems in her lifetime. She has constantly struggled with substance abuse problems, either by her own choice or by virtue of being involved with other people who are using.
Hang on one second. Zolisa, I'm curious. You wrote a paper about probably poverty and in the criminal justice system and everything, and that cycle. I'm curious about that. In either, if you want to call the burner phone, obviously that's an option. But did your paper suggest a solution? Or was it just an analysis of the situation? I'm curious what the fix would be in your mind, or possible fix that we could do to fix it. You should catch that living on a load of goats. We're not just living on a load of goats up here. Where's this court at? This one that we just barely bailed on is, let me check. That's Judge Colin Hunter Kalkaska. Sounds like a Michigan thing. Where's Kalkaska? I don't know. It came up on my feed of courts that are in session currently. Let's see. Judge Sean Perkins. I don't think he's live right now. He's a fun one to watch. If you're wondering what we're doing today and why we're not watching Tyler Robinson, it's because it hasn't started yet. The judge has said we're going to get a half day of Tyler Robinson hearings today. And then we're going to, oops, that's not the one, this one. Then we're going to be over halfway done with the hearing window. We have 5 days to have this preliminary hearing. Only a half day on Wednesday, right in the middle. So 2 more days. The state still isn't rested yet. The defense does get a chance to put this on. I'm not sure if we're going to get it done in time. But we're doing a little bit of court hopping around to see what's happening in some of the fun courts we like to follow. We haven't been to Judge Boyd's courtroom in a little while. She's speaking to people. Let's see what's up here.
You will have knowledge of what you're being accused of, because it would be a shame for you if you get that ticket and you say to yourself, you know what? They're saying I ran a red light. I know I didn't. That was a stop sign. And then you show up to municipal court and you're ready to go to trial and you're sitting there and you're doing your jury selection. And then all of a sudden you find out they're accusing you of running a stop sign. So that's what an indictment is. It's just a piece of paper to give somebody notice. It can't be taken as evidence by you. Does everyone understand? Yes. So the question becomes, is anyone going to hold it against Mr. Gallegos because he's here under indictment?
This is a jury selection.
Now, the next thing I want to talk to you is certain rights that anyone who's accused has. Number one is the right to remain silent.
That's a nice purse.
What does that really mean? That means that you don't have to testify. So the state can't, as a part of their case, say, you know what, we're going to call the person who's accused. The person who has the right to say whether they will testify or not is the person who's accused. I've been a defense attorney. I've been a prosecutor. There are many reasons why somebody may choose not to testify. Sometimes people are just scared of public speaking. I would have some clients, I would talk to them. I said, look, you're sweating and nervous and you're talking to me and I'm your friend. I'm here to fight for you. You would not make a good witness. And then sometimes I would be in a jury trial and I would tell my client, the state didn't even prove their case. There's no reason for you to testify. And it never fails. There's always a juror or a potential juror who says, well, if that were me, I would want to tell my story. And I always chuckle inside because I'm like, it's not you. You don't have an expert telling you what is your best option or what you should do. people tend to look at the legal profession different from any other profession. If somebody were getting heart surgery, you may go to your first doctor and the first doctor's like, hey, you need heart surgery right away. And you're like, I'm getting a second opinion. You go to the second doctor. The second doctor says, yeah, you should have got this heart surgery yesterday. And you're like, I'm gonna go to the third doctor. And the third doctor tells you, you should have got heart surgery, 2 days ago. You would never tell that doctor, you know what? I know what you're saying, but I feel like I shouldn't be doing this. Or either I'm going to go forward with the heart surgery, but let me just tell you what scalpel I want you to use and how we're going to do the stitching. So I always tell people that because whether or not somebody's accused, someone accused of a crime decides to testify, that is completely up to them. And you can't hold it against them if they decide not to testify. You can't say, that's a mark against them. They didn't testify. You can't consider it at all. During deliberations, you can't even bring it up. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. Gallegos if he decides not to testify? Right. Now, the next thing I want to talk to you is about the presumption of innocence. Everybody who is charged with a criminal offense is presumed to be innocent. What does that mean? That means that the state has the burden of proof, and they have to prove each and every element of a charge beyond a reasonable doubt. Our professors in law school would try to instill in us, one, you don't have the burden as a defense attorney. Your client doesn't have the burden, and your client is cloaked in the presumption of innocence unless the state proves their case beyond a reasonable doubt. So our professors would always tell us, you can sit over there, you can do crossword puzzles, you can play video games, you don't even have to pay attention to what's going on. You don't have to question any witnesses. And they instilled that into us because they wanted us to be sure that we understood that as the defense, you do not have to prove anything. As the defense, your client is presumed innocent. Does everyone understand?
Yes.
So right now, how much evidence have you all heard in this case? So if you had to decide on whether Mr. Gallegos is guilty or not guilty right now, what should your verdict be?
Not guilty.
All right. Now, let's get to the burden of proof. What's the burden of proof in this case? The burden of proof is proof beyond a reasonable doubt. What does that mean? What is the definition? When I was in law school, and I'm slightly older than these attorneys, like I say, I'm 20, they probably like 19. There was a definition for proof beyond a reasonable doubt. You had to know it forwards and backwards. And if you didn't know it, you felt like a failure. I memorized that definition. I can still quote it. I knew where to put my commas when I was speaking, the explanation points. I knew where to pause for dramatic effect. And then after my first jury trial as a defense attorney, you know what happened? They did away with the definition. So there is no longer a definition for proof beyond a reasonable doubt. Now, I just told you the burden of proof is proof beyond a reasonable doubt. So you're probably asking yourself then, how do we know if the state has met its burden or not? So as a defense attorney and as a prosecutor, I said, you know what? The best way to explain it to a jury is by telling them what it is not, so they won't lower the burden. So next door, you have the historic courthouse. That's the courthouse with the green rooftop. Over there, they try civil cases. So fender benders, when you see people on the freeway and they get bumped from behind and they don't want to move to the emergency road because they think they're going to get $1 million and it's just a fender bender. Those cases are tried next door. And the burden of proof is preponderance of the evidence. What is that? More likely than not, something happened. So if you're ever in a criminal case and you're deliberating and one of the jurors said, well, I believe this happened more likely than not, you need to tell them, excuse me, we're in the criminal courthouse, we're not on the civil side, you're at the wrong burden of proof. That's their first burden. Their highest burden next door is what's called clear and convincing evidence. Clear and convincing evidence is the type of evidence that is used to terminate people's parental rights. What do they say? They say that you're a danger to your children, so you will no longer be allowed to legally be their parent, and they terminate your rights. And I think everyone here would agree that should be a high burden. If somebody's going to come up and take my children away from me for the rest of my life, well, it is a high burden. But you know what's higher than that? Proof beyond a reasonable doubt. That's the highest burden we have. Does everyone understand? Now, there are two phases to a trial. First phase, people love to call it the innocence phase. That's not correct. It's not an innocence phase. The first phase is, did the state prove their case or did they not prove their case? That's it. It's not, oh, is the person innocent or not innocent? No. It's, did the state prove their case or did they not prove their case? So if the state doesn't prove their case beyond a reasonable doubt, what should your verdict be? Oh, y'all are very quiet. Y'all need to, let's wake up. If the state does not prove their case, then what should the verdict be? Guilty. All right. So if your verdict is not guilty, then there's no phase two, because phase two is correctly called the punishment phase. And in phase two, you decide somebody's punishment if you found them guilty. In this case, the range of punishment is up to a $10,000 fine. Usually people get stuck on a $10,000 fine. $10,000 fine doesn't go to a complainant. It goes into the coffers somewhere in the multiverse. All right. But the other range is anywhere from 2 years in the prison up to 20 years in the prison. What does that mean? That means you could potentially sentence somebody to 2, 3, 4, 5, 6, all the way up to 20. Also, there's a possibility of probation. So that is the range of punishment for this type of case. Does everyone understand? Has everyone internalized what the range of punishment is?
Yes.
So attorneys will always ask you, well, can you give 2 years in this case? Can you give probation? Can you give 5 years? That is an inappropriate question. The only thing they're allowed to ask you is whether you can consider the full range of punishment. And the full range of punishment for this type of case, if you find someone guilty, is anywhere from probation up to 2, 3, 4, all the way up to 20 years in prison and up to a $10,000 fine. Does everyone understand?
Yes.
Now, usually when people saying can you consider the full range of punishment, it never fails jurists like, well, I don't know if I could give that. That's not the question. The question is whether you can consider the full range of punishment. And for some jurors, and if I were a juror, it would be me too. I would say, if I wasn't in the legal field, I would say, you know, if I know the facts of the case, then I would be able to tell you what I would give. Well, guess what? You're not going to know the facts of the case unless you're on the jury. So with regards to the range of punishment, everyone has told me that they've internalized the range of punishment. They know what the range of punishment is. So if someone were found guilty of this type of offense, the question becomes whether or not you would take whatever facts were given to you and use those facts to come at a range of punishment, if you can come at a range of punishment. Does everyone understand? So is there anyone here who would be unable to do that? All right. Now, the next thing I want to talk to you about is fairness. Attorneys will always ask you, this is the type of case this is. Are you able to be fair? Can you be fair? And people are like, I don't know. So let me explain to you what fairness is. Let's say, you know, you have jury duty and you're going to do your civic duty because that's who you are. You're an American, and by goodness, you're going to do your civic duty. So what you do is you get up the day before you have jury duty and you do a dry run because you want to see, is there another construction that has mysteriously popped up? So you take the route, You look at everything, you know where you're supposed to park, you know where you're going to be coming, you've done the dry run. So the day it's for you to start jury duty, you get up in the morning, the weather is nice. It's 72 degrees in San Antonio in the summertime. There's a slight breeze. You're like, why do I have the AC on? I don't even need the AC. The weather is so perfect. You get up, you fix your breakfast, the birds are chirping, you come downstairs, and your vehicle is on cinder blocks.
Sorry.
But you're
That's
going to do your civic duty. So you get an Uber or Lyft, or your neighbor takes you, you come downtown, and you're standing outside in the cool hallways, waiting to be called in. You come in, and I tell you, okay, we're here for a burglary of a vehicle. Usually people will say, you can't be fair, can you? This is what fairness means. Even though your vehicle was burglarized, are you going to hold it against someone who's accused of burglary of a vehicle? Are you going to say, you know what? I'm not even going to listen to the facts presented. My vehicle has been burglarized, and this person is charged with burglary of a vehicle. I'm just going to find them guilty. I don't even care. That's what fairness means. Fairness is basically this. Are you able to listen to the evidence that is presented to you? And if you can come to a decision, base that decision upon the evidence that is presented. Is there anyone here who cannot do that? Now, the next thing I want to talk to you about is intoxication. Raise your card if you have ever, you believe, drank to intoxication before. All right, I should ask the reverse question, right? But no, keep your card up. I'm going to call your number. So it's 3, 4, 6, 8, 9, 11, 14. And when I call your number, you can lower your card. 15, 16, 20, 21, 22, 23, 13, 24, 25, 26, don't be shy, 26, 27, you can lower your card, 31, 19, 33, 20, 34, 21, 35, 22, 36, 33, 37, 24, 38, 25, 39, 26, 40, 27, 41, 28, 42, 29, 43, 30, 45, 31, 46, 32, 50, 33, 51, 34, 55, 54, 58, 59, 61, 62, 63, 64, 65, 66, 66, 69, 70, 71, 72, 73, 74, and 75.
So 52 out of 75 people.
Raise your card if you have ever been the
there.
designated driver.
Not going to read all these ones, are you, Judge?
Oh, the same people who had the, all right.
All the same 52
All
people.
right, designated drivers, 1, 6, 7, 8, 9, 11, 12, 14, 15, 17, 19, 20, 22, 23, 24, 25, 26, 27, 29, 31, 33, 34, 35, 36, 39, 40, 42, 43, 44, 45, 46 through 48, 49, 50, 51 through 56, 58, 57, 61 through 64, 65, 66, 69, 70, 71, and 72. All right, raise your card if you have ever been around anyone who was intoxicated and you felt they needed your protection. Number 1, 3, 6, 7, 8, 9, 11, 12, 14, 16, 17, 19, 21, 22, 26, 28, 29, 30, 31, 33, 34, 35, 36, 38, 40, 41, 43, 45, 46, 47, 41, I've called you, 48, 51, 53 through 55, 59, 60, 57, 61, 63, 64, 68, 67, 69, 70, 71, 72, 73. All right. Raise your card if you've ever had to defend physically someone who was intoxicated.
Like they pick a fight and you have to fight it for them?
That's number 3. Number 6, 21, 22, 36, 38, 48, 59, 61, 63, 67, 69, and 72. Of those who raised their card for that last question, raise your card if
you took a charge for them.
It became violent. You're defending the person.
With the fisticuffs.
Number 3, number 6, 21, 22, 48, 61, 63, 67, and 72. And 15, you don't have your card up, correct? All right. So I'm expecting this trial to conclude no later than Friday. Is there anyone who has any type of time constraints with regards to that? And let me explain to you.
Let's get some good excuses going, Judge.
Testimony would likely begin tomorrow at 1:30. So if you have a time constraint, please raise your card. That's 6, 21, 26,
3,
27,
4,
2,
5,
9,
6,
22,
7. People are being timid about
32,
8,
35,
9,
36, 37,
11,
41,
12,
53,
13,
58,
14,
63,
15,
72,
16,
75,
17,
73,
18,
and 69.
So about 19 or 20 out of 75.
Number 2, what's your time constraint?
Let's hear it.
All right, so you're all going to have to speak up so the court reporter can hear and I can hear it. Yes. Where to? Where to? All right, and when
Going on vacation
are
to
you
Texas.
proposing to leave?
She's in Texas.
And you say in the morning, what day is this? Friday? All right, number 6.
I have work. I started a new job recently, and I'm still in training, and there's really no way to pick up without this.
All right.
Have work. That
Number
night,
9.
That won't
I
work.
have to move in my daughter to her dorm, which is in Lubbock at Texas Tech. So I need to move in Friday and Saturday.
Friday and Saturday just to
What
drop
time
his daughter
Friday?
off at college.
Well, we're eligible to get in there as early as 8 a.m.
But when would you be leaving to Lubbock?
Night before Thursday night.
Mhm.
So I can spend the night, get there Friday morning, move early Friday all day, Saturday all day. That way she can start her summer courses.
All right, and that is not an SCC team, is it?
No, it's a
Judge has her favorites. We need some good
All
excuses
right,
here.
number 21.
That's financial constraints. I have to work in the provider of my household.
Sole provider.
Based employees, so my absence is like, presence there.
All right, number 22.
I've got reservations at Rockport. Already up there at Good leaving around noon on Friday.
All right, what are you doing in Rockport?
Oh, fishing.
I thought fishing. So, what type of fish?
Anything we need.
Okay.
Going fishing,
Thank
Judge.
you.
I've got reservations for fishing.
All right, number 26.
Work and got cows that are calving, and we got the screw worm right there.
Rancher says,
All
I've
right,
got
thank
work.
you.
The cows are calving. I can't
Number
just put that
27.
off.
Work.
Work.
Thank you. 32. I'm sorry, what? All right, thank you. 35.
You said 1 o'clock? My appointment's at 8:30, so it should be fine.
All right, thank you. 35.
Oh, that was.
I'm sorry. It was 36.
Work sole provider for a family of 5.
Thank you. 37. I'm sorry, I didn't hear you. You say you have no transportation.
We could send the
All
sheriff.
right,
to
and a
pick you up.
manager where?
Sonic Garden?
Okay. All right, thank you. Number 41.
My parents are elderly and I depend on them vehicle wise, and they're also watching my dog. Doctor's appointments this week.
All right.
Elderly parents he has to
53.
care for, plus a dog watch.
Going out of town tomorrow.
And where you seem very happy about that. Where are you headed? All right, when? What time?
Can't hear.
And when you say we're going, who is we? Okay. You're leaving your family behind. Okay. All right. Thank you.
That's why she's happy.
Number 53. I'm so sorry. I'm getting different numbers up here. Number 58.
Work/doctor's appointments. I'm the PCP for homeless vets in this area, and local appointments have been canceled.
All right. And when is your doctor's appointment?
It's not for me, it's like I'm taking care of patients.
Okay.
So morning, unfortunately night.
All right. Number 63.
I'll be going out of town to South Padre/Port Isabel. I am hosting a wellness event for the community there.
I mean, do you want to do that? I mean, is it hosting a wellness event? Isn't that sort of like dealing with other people's problems?
Yeah, before I walked in, KRGB TV5 would like me there at 2 on Friday to promote the event.
All right. Thank you. Number 72.
Yes, I'm operational owner for 2 bars. I'm here in Antonio wanting to come out, and I'm just at my peak season right now, so very short-handed.
All right. So you say 2 bars?
Yes, ma'am.
All right. And what is that? I mean, I know what a bar is, but what are the bars' names?
The Rose of San Antonio downtown and River Roads Tavern and Canyon Lake.
Your Honor, I can't do jury duty. I run 2 bars.
All right. And in your occupation, have you ever?
Yes, ma'am. I've been doing this 30 years.
Yeah. Have you ever dealt with people who were intoxicated?
Yes, mostly on
on a daily basis.
And have you heard of a Coca-Cola drink where you put wine in it or something? Yes. Okay, I'm just wondering.
Lunch order? Is that what we're hearing?
Okay, and I'm sorry, what was your number again?
72.
All right, thank you. Number 75.
I'm a registered case manager. I'm starting to
All right, thank you. And then 69.
Stitches in the top of my head that are coming out on Friday night, 30th, back.
All right.
Scheduled
That is so nice of you. Thank you.
Older, that's pitching.
Oh. All right, number 73. All right, thank you. All right, so next thing I want to ask, raise your card if English is not your primary language or your first language. All right, that is 46, 63, and 67. Oh, and 47? All right, 46. Yes. What is your first language? All right, thank you. Number 47? All right, thank you. 63.
Spanish.
67. Thank you. And have all of you
Spanish.
been able to understand everything?
Yes.
All right. I always ask that question because sometimes, believe it or not, we will have people or we've had people and they haven't understood certain things because of a language barrier. I was never supposed to be in Texas. So of course, when I was in junior high, now you call it middle school, my best friend was like, Stephanie, you and I, girl, we need to take Spanish. I'm like, I'm never going to need that. I'm like, we're in Louisiana. I'm taking French. I'm going to be retired in Paris by the time I'm 21. And lo and behold, I ended up here after undergrad and grad school for law school. And I'm like, curses, I should have taken Spanish. So I've been working on it. If my Spanish is not what it should be, then you can blame the deputies because they're supposed to teach me. And so far, all I got is de nada. So we'll work on that. Now, the next thing I'm going to do before I turn it over to the state and defense to ask you questions, and they each will have 30 minutes to ask you questions. I'm going to tell you two stories, and both of them are true.
Ooh,
I will always see people who don't want to serve jury duty, right? And I tell people jury duty is an inconvenience, it's not a sacrifice. Why do I say that? It's an inconvenience because one, you got to pay for parking. And you're probably thinking, I'm doing y'all a favor and y'all are making me pay for parking. All right. So, and then you have construction and they're constantly doing one ways downtown because somebody did a study at one point who thought if you have a bunch of one ways that'll make traffic flow easier. And it really doesn't because you'll see where you're supposed to park and you can't turn because it's one way. And then it's sort of like a hurry up and wait. So I tell people that's an inconvenience. This is what I consider a sacrifice. So my family grew up in a small town called Grand Cane, Louisiana. And my uncle, super intelligent. Before this computer thing became like just
it's a fad, judge of
common,
the pass.
He already knew about computers. And so my grandmother would send him to school. And the teachers will tell him, Miss Lane, we've taught him all we can teach him. And they would send him to the next grade. And that was back in the day, maybe because the schools were smaller, the classroom size were smaller. The teachers not only knew every student in their class, they knew every student at the school. Now, when my aunts and my other uncle went to high school, they were not very happy with my uncle because the teachers told them, this is the gold standard. Now we know where he comes from. This is what we're expecting for everybody. So my uncle graduates from high school and a conflict breaks out. You may have heard of it, called the Vietnam War. And he goes to my grandmother and he's asking my grandmother to approve him entering the military. And he tells my grandmother, because what's happening with civil rights, there's no way for me to improve my lot in life here. And so that was my grandmother's firstborn. And she had to sign to send her child off to a place that she had never heard of before. And my grandmother was super intelligent. She only had a 6th grade education, but she babysat me. She taught me how to read, tell time while my mom was at work. She taught me how to tell the insurance salespersons that would knock on the door, no, thank you, we don't want any. I did say yes to the childcraft books and the encyclopedias, which I still have. My mom was shocked by that, but she allowed me to have those. So that was back in the time where there were only 3 stations. This whole thing with young people where you say, oh my gosh, there's so much on television. They're playing the same thing over and over. Well, back in the day, you only had 3 stations, ABC, CBS, and NBC. NBC, you really couldn't count on. If there was a breeze, don't even let it rain because you're not going to be able to get that channel. And then it wasn't 24 hours. At some point, the programming would end. And then when they got high tech, they would play the national anthem and the flag would be blowing in the wind, or either you just have static and you'd have to wait for the next day for news. And my grandmother did have a phone, but her phone didn't have any numbers on it. And young people were like, well, how do you talk on that? I always tell people, you can tell what era people were born in by looking at their index finger. I'm the rotary era because, you're trying to win the contest from the radio station. I was so happy when we finally got touch tone with the redial because you're like, I'll get it down. So my grandmother would pick up the phone and the operator would answer and you tell them who you wanted. That's why you would have songs like Beechwood 45789 because you want the person who's at Beechwood 45789. So my grandmother had his name and the number they gave him from the military. And she would send letters to him and she would have to wait the letters to come back. And Grand came, small country town. So it would have to go through the big city, Shreveport, Mansfield. And if you look up those cities, they're not anywhere near as large as San Antonio. So she would wait to get letters back from her firstborn son, who she's sending off to fight in a war. And I would always end that story at that point until the deputy said, Judge, what happened to your uncle? Because my grandmother's like, hey, there are people in military uniforms knocking on other people's door. This is not good news. Well, my grandmother got a knock on her door about her son from people dressed, and they were dressed in uniform. And she learned that her firstborn son was severely injured. He ended up surviving and he continued to remain in the military. And he would always come back. And because at that time I was the youngest niece, he would always come back from wherever they had stationed him and bring me a gift back, give me a hug. That is why whenever I smell Old Spice, it makes me think of him, because back in the day, that was your male rite of passage. You can now wear Old Spice. But he has since passed. Some of my aunts have since passed, but I always remember that. And so I always tell that story to tell you that what you're doing right now, it's an inconvenience. It's not a sacrifice. I always see people 4th of July, Memorial Day, Veterans Day. You want to wave your flags, and then your country asks one thing of you, to serve on a jury, and people don't want to do it. So raise your card if you have ever served on a jury and actually listened to testimony. So that's 1, 5, 7, 13, 17, 26, 27, 31, 39, 40, 48, 51, 60, 64, and 75. So raise your card if the trial that you sat on was in Bexar County. That's 5, 13, 7, 26, 27, 31, 39, 40, 51, 60, 64, and 75, and 27. Raise your card if that was a criminal case. That's 5, 7, 13, 1, 31, 64, 75. Raise your card if a verdict was reached in your case.
The numbers are getting smaller and smaller.
5, 7, 13, 17, 26, 27, 31, 39, 40, 48, 51, 64, and 75. Now, each side will have 30 minutes to speak to you. My friend and I, who went to law school together, she does civil work. No offense to the civil attorneys, but usually they're not in trial every week and they're not in court every day. So she got called up for jury duty and she said, Stephanie, let's do lunch. I'm like, great. And it's like no time had passed since the last time we were in law school together. So I asked her, how is jury selection going? She tells me it's going fantastic. I'm wondering, how could it be going fantastic? What do you mean? She said, I'm not going to be selected. It's just like law school. I'm keeping my head down, not answering any questions. So I start laughing. She says, what's funny? I'm like, I'm just happy because we're going to have lunch together all week. So other than remaining quiet, the quickest way to be on a jury trial is to raise a card and say, please put me on this jury. I desperately want to serve. The state and the defense, regardless of what you've seen in television shows, they only have 30 minutes to talk to you. They don't have anybody to go out and look through your trash can or anybody to, go to your house for dinner to find out who you are. This is the only time they will be able to do that, okay? Does anyone need a break before I turn it over to the state? All right, we're going to take a break. Do you all want a lunch break or a short break?
Lunch, Judge.
All right, so I'm going to give you all a 10-minute break.
No lunch.
Look to your left. Look to your right. You're responsible for making sure that juror is in line. So please leave the cards behind. And when one person leaves, everyone must leave, and you're going to be lined up outside. Don't come back into the room, okay? Everyone, please rise for the jurors.
And with that, they're going on break. I like watching. We've seen and heard that exact discussion, that exact conversation with the judge, almost verbatim before. Judge Boyd is finishing her service this year. She was, as judges are, they are up for re-election. She lost her re-election in a primary, so her last December, the end of this month, end of this year, she'll be done. She will not be a judge anymore. She might be nominated again or a different position. She might still, she might go back to being a lawyer. She might retire. I don't know. I haven't heard from her what her plan is, but she's one of the good ones. She's had moments of controversy for sure, as many judges have, especially ones that are willing to live stream their court proceedings day in and day out. That puts a little scrutiny on you. So that's really cool. Selena here in chat with us right now. She's lined up number 2 in the line for the public entrance into the Tyler Robinson hearing. So Selena will be back in court today, watching that. She's waiting for a wristband right now. We will be live streaming that hearing, and hopefully live streaming on Top Mark Media as well with fixed audio, because the pool feed only comes in with one channel of audio, and so we'll switch it to mono and do some adjustments on that. Hopefully, Top Mark Media is fixed over there. We won't have a problem. We have to make sure we don't accidentally show the Live View logo, because apparently that's copyright from a cricket match in India. Excuse me? Yeah, that happened. So we'll do that, and we'll be going over there shortly. It's 1 o'clock right now. We're starting at 2:30, so I think we're going to take a lunch break, right? Let me check my. Let's see, what do we have? Tyler Robinson. We are starting there at 2:30, so we have an hour and a half. That's a little bit of a long lunch, but we can portal over to that. And if you want to just hang out and chat and talk, that would be great. That's awesome. But I'm going to get some things ready on the Top Mark side with a splash screen I can put up just in case KSL decides to put up their live view placeholder, which is not copyright, just to prevent a problem on the Top Mark Media side. And also get a bite to eat. Thanks for court hopping with us. We haven't done this in quite a while. Well, it's been a little while. It's fun to pop back into some of the courts and the judicial process around the country and see how it just progresses every day, all the time, every day. Every business day, courts across this nation are having very, very interesting, compelling court procedures, court hearings, arguments, and trials that we just don't hear about. That just because it wasn't a high-profile event, or the defendant didn't have a well-known name, or maybe it's because there was other big news that day, and this news didn't hit the radar. We like dropping in and finding some of those and some of the small cases as well. I'm a big advocate for transparency in the justice process from top to bottom. So thanks for doing this. Live view is not cricket. No, I actually have a cricket bat, an actual cricket bat and ball. Had until I moved here. I think I got rid of it. I've never played. It was a gift to me from a lady I met over in England when we were over there. She's like, "You need a cricket bat." I'm like, "I don't understand. I barely know what a wicket is, let alone the rules." And they tried to explain it to me. It didn't help. Anyway, I think we donated those to a thrift shop. So somebody out there, I donated the cricket bat, the ball, and the oil. I think it's like linseed oil you use on the bat to to protect it. All right. I like this idea. I feel like it'd be easier to get my own cow. Milk, unlimited milk, right? That's the idea. Of course, you need to milk it. So, miss Foliage Fridays. Well, one of these days we'll get back to one of those cases. I think, is there anything else we need to do? We're going to be going live with the Tyler Robinson hearing. Selena Kay is back as a court watcher. We're so excited for that. Selena, I got your text message. I'll see if we can work on that offline, and maybe share something online when the time's appropriate for that part. But excited to have you back in court. Hopefully, it's a little more interesting than we had yesterday with a lot of the DNA testimony. We're still on the third witness for the prosecution, and then we took this DNA expert out of turn because she could only be there yesterday. That now we're going back to that third witness for the state, so it's going back to the state's case in chief, and it's going to be fun. Raise your card if you care about judge life experiences. Greg, I assume from the way you wrote this that you didn't raise your card on that one, and that's okay. That's okay. All right. Lunchtime, then we'll be back. The portal's already built. We can portal over there, and we'll be back maybe a little bit before 2:30. Depends when I get all the things I need to have done here. Wake me up at happy hour, says Greg. You saw how the judge just perked up and she's like, "Oh, you run 2 bars. Tell me about this drink with Coke, Diet Coke and wine. What is that?" I shared a house with a cricket player and still don't understand cricket. Yeah, it's a tough one. I've watched it on TV. I've watched the matches. It's crazy. We'll get a recap when we come back, which is the live stream for the Tyler Robinson hearing on the next live stream after the portal. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again. It's slated for 2:30. Which is in an hour and a half from now. We might be a little bit early. Sometimes we're early. It happens, guys, I promise. But Regina, you did a great job with the internet today. Whoever's first in chat on the Tyler Robinson live stream, good luck. Good luck. We're all dependent on you. We'll see you guys. Have a great lunchtime. We'll see you in a little bit. Bye-bye.